Okay, right. Good afternoon, distinguished dignitaries, eminent speakers, respected faculty members, participants joining us from across the globe. It gives me an immense pleasure and the deep sense of honor to welcome you to this 2 days international webinar on legal governance and green technologies for sustainable agriculture, jointly organized by the Department of Studies in Law, University of Mysore, GSS Law College Autonomous Mysore, Green Life Crop Tech Private Limited, Mysore, Karnataka. This event, spanning over two days, intellectual stimulating to look at the confluence of the law, technology, and sustainable development to oversee the global sustainable future. In an era where sustainability is no longer a choice, but it is imperative. Agriculture, our world industries are all undergoing to profound transformation. The challenges of climate change, environmental degradation, and the digital revolution compel us to think not only to cultivate the crops, but also to think how law, policies, and technologies can sustain life itself. This webinar emerged from the very necessity to deliberate over the legal framework to govern green technologies and to redefine legal ecologies and the stewardship to build ethical models of the green agriculture and govern that harmonize productivity with planetary balances. I wish to extend a gratitude to the chairman of Department of Studies in Law, Professor M.S. Benjamin, and Professor K. Suresh, the Chief Executive of GSS Law College, and Dr. Vasant Kumar, who made this collaboration possible. This collaboration exemplifies the synergy between the academic inquiry and real world. Over the 2 days, this platform will navigate broadly, but also it is deeply interconnected to these dimensions. Over 2 days, we shall discuss regulatory frameworks for green technologies, IPR and technology transfer, governance of biotechnologies, AI, big data, precision farming, blockchain and supply chain, crop tech and startups, and so on. Each session of this program carefully curated to foster cross-disciplinary dialogue between the legal scholars, technologies, and policymakers, envisioning a jurisprudence of sustainability frameworks that sees innovation not as a disruption, but it is a regeneration. The primary objective of this webinar to discuss interdialogue to bridge between law technologies in the service of agriculture. And we shall collectively discuss how can legal governance enable responsible innovation, how might green innovation be harnessed for the green and inclusive growth. And most importantly, what we discuss today is how agriculture can evolve as a domain of ethical, ecological, and economic growth. So, ladies and gentlemen, let us begin the program. Now, I would like to request the president of today's program, Professor M.S. Benjamin, the chairman and Department of Studies in Law, University of Mysore, to deliver the welcome address and formally inaugurate the today's program. Before, sir, we proceed with you and you take the virtual stage, I may request Ms. Janvi Suresh to introduce you briefly to the audience, then we proceed ahead.
Thank you. It's my privilege to introduce Professor Dr. M.S. Benjamin, Dean Faculty of Law, Chairman of Board of Studies, PG, Chairman of Department of Studies in Law, an eminent academician and distinguished legal scholar, presently serving as a Professor of Law at the Department of Studies, Research in Law, University of Mysuru. Dr. Benjamin, sir, teaching and research interests lie primarily in comparative constitutional law and comparative administrative law, with special focus on business law. Over the years, he has made significant scholarly contribution, authoring more than 28 research papers as a sole author on diverse subjects ranging from medical negligence to labor law. His work has been published in reputed journals, including the Supreme Court Journal and the Labor Law Journal. In addition to his research pursuits, Dr. Benjamin has served as an editor of the book titled The Status of Human Rights During COVID-19 Pandemic, published by Prasanga, University of Mysuru. He has been teaching courses such as Comparative Public Law, Research Methodology, Human Resource Development, for over a decade, nurturing the next generation of legal scholars and practitioners. Prior to joining the University of Mysuru, Sir held the position of Vice Principal at reputed law college and has practiced criminal law. He has successfully cleared both the Judicial Service and the Prosecution Service examination, reflecting his deep engagement with the practice of law as well as academia. Sir holds an impressive array of academic qualifications: BCom, LLB, MA in International Relations, MA in Human Rights, LLM in Constitutional Law, and PhD in Law. His dedication to teaching, research, and development of legal education continues to inspire students and colleagues alike. Thank you, sir. We welcome you, sir.
Good afternoon and good evening, respected chief patrons of the program, Professor Lokanath, Honorable Chancellor, University of Mysore, Srimati M.K. Savita, Registrar, University of Mysore, patrons of the program, Professor K.S. Suresh, Chief Executive, KSS Law College, Dr. Vasant Kumar, Timakanapura, distinguished guest, Professor Shaiwal, Satyarthi, Professor Sreenivasulu N, Professor M. Viswanath, Professor Sanjit Kumar Chakravarti, esteemed colleagues, dear participants, and ladies and gentlemen. On behalf of the organizing committee, it is my great honor and privilege to welcome you all to this important international webinar on legal governance, green technologies for sustainable agriculture. This program is jointly conducted by the Department of Law, University of Mysore, the Mysuru, JSS Law College Autonomous, the Mysore, and Green Life Crop Tech Private Limited, Mysuru, Karnataka. We are delighted to have with us an outstanding assembly of policymakers, legal experts, researchers, environmental advocates, agricultural innovators, all united by one vision: laws governing green technologies for sustainable agriculture. There are three important aspects in the webinar, the theme or the topic: sustainable agriculture, green technologies, and the laws relating to it. In order to tackle global challenges such as climate change, resource depletion, food insecurity, the world is focusing on sustainable agriculture that enhances agriculture production without compromising environmental integrity. Sustainable agriculture will satisfy human needs while maintaining the quality of the environment and conserving natural resources. In recent years, we have also witnessed the rise of green technologies such as organic farming, agroforestry, integrated pest management, renewable energy, biogas technology, agricultural biotechnology, and so on. These technologies can be implemented without damaging environmental stability. Therefore, it is called as green technology. However, technology alone is not suffice. Laws and policies governing green technologies also play an equally vital role. Around the world, states are enacting laws to promote green innovations in agricultural sector. We have IPR laws, in particular, the Protection of Plant Varieties and Farmers Act, which protects the innovation of technologies, environmental laws, which maintain environmental stabilities, national policies for advancing sustainable agriculture by providing a subsidy or financial support, fostering research and innovation, international policies and treaties like Paris Agreement and WTO TRIPS Agreement that promotes eco-friendly practices for sustainable agriculture. With this brief background of the theme, I heartily welcome the chief, the patrons of the program, Professor Lokanath K.S., Honorable Vice Chancellor, University of Mysore, Srimati M.K. Savita, Registrar, University of Mysore, patrons of the program, Professor K.S. Suresh, Chief Executive, JSS Law College, Autonomous, Dr. Vasant Kumar Timakapura, Chief Scientific Advisor, Green Tech, Crop Tech, the Mysore. I heartily welcome today's chief guest of the program, Professor Shaiwal Satyarthi from National University of Juridical Sciences, Kolkata, West Bengal. Guest of honor, Professor Sreenivasulu from West Bengal, National University of Juridical Sciences, Kolkata, West Bengal. Distinguished speakers, Professor M. Viswanath, Dean, Faculty of Law, Karnataka University, Dharwad, Karnataka. Professor Sanjeev Kumar Chakravarti, Director, Center for Law and Justice, National University of Juridical Sciences, Kolkata, West Bengal. I also welcome organizing the members who are instrumental in conducting this program. Dr. N. Vanisri, Principal, JSS Law College, Autonomous, Mysore. Mr. Qudrat Syed Hasmi, Mrs. Sheila Ganesh, JSS Law College, Mysore. This webinar provides an opportunity to share knowledge, to learn from scholars, and to explore how legal instruments can foster green technology for sustainable agriculture. I once again welcome you all and thank you for joining this important international webinar. Thank you one and all.
Thank you, sir, for your insightful and inspiring words. Now, it gives me an immense pleasure to invite the chief guest of the today, Professor Dr. Shaiwal Satyarthi, Professor at Faculty of Law, University of Delhi, to deliver the inaugural address. Sir, before we proceed with you, may I request my colleague to introduce you to the audience.
It's a privilege and honor to introduce a distinguished academician, researcher, and legal scholar, Professor Dr. Shaiwal Satyarthi, Professor of the Faculty of Law, University of Delhi. Professor Satyarthi holds a PhD, LLM, and LLB from the prestigious Banaras Hindu University and a BCom from the University of Delhi. His academic journey has been one of consistent excellence, marked by a deep engagement with evolving intersections of law, society, and global governance. Before joining the University of Delhi, he served as assistant professor at Chanakya National Law University, Patna, where he inspired generations of students and contributed extensively to academic and institutional growth. His intellectual pursuits reflects a rare blend of depth and diversity, spanning intellectual property law, TRIPS and WTO law, traditional knowledge, family law, and social justice. Professor Satyarthi is also a regular visiting faculty at the Bihar Judicial Academy, where he trains and mentors members of the judiciary. His association with the Bar Council of India as a member of various committees further reflects his enduring contribution to shaping legal education and professional ethics in India. A prolific author, Professor Satyarthi has written and edited several notable works, including his widely referenced book, TRIPS Agreement and Intellectual Property Rights Regime in India, and the co-edited volume, Evergreening of Patents. His scholarship consistently bridges the gap between the theory and policy, offering pragmatic insights into how legal systems can advance both innovation and equity. Some of his notable works include an article titled Why Traditional Knowledge is Incompatible with the Intellectual Property Rights, Practical Implications and Illustrations, published in the Journal of Central European Green Innovation, another on environmental governance in the modern era in the Indian Bar Review, and a paper on judicial review of legislations, a comparative study in the in the Chota Nagar in the Chota Nagpur Law Journal. His recent article, Deconstructing Anti-Corruption Clauses in India's Model Bilateral Investment Treaty, offers a critical perspective on India's investment treaty framework. Beyond academic publications, his book chapters delve into contemporary concerns such as gender justice and live in relationships, protection of children from sexual offenses, and transgenders and human rights, revealing his deep sensitivity to the evolving dimensions of human rights and social justice. Professor Satyarthi's intellectual legacy stands as a testament to his pursuit of just and inclusive legal order, one that harmonizes modern law with ethical and cultural values. We are truly honored to have him with us today to share his insights on legal and regulatory frameworks for green and sustainable agriculture. Please join me in welcoming Professor Dr. Shaiwal.
Sir, we are delighted to have you with us. Please take this stage. Go to this.
Okay, thank you. Thank you so much for all your kind words. Very good afternoon to all participants. First of all, I would like to thank organizers of this international webinar for giving me this opportunity. So it is definitely a profound honor to join you today as the chief guest of this international webinar on green and sustainable agriculture. And I'm really thankful to the organizers. This topic is very contemporary, and it is very important to discuss this particular issue which I am going to raise in this particular deliberation. So first of all, I would like to tell you something about our connect with this kind of issue. So during my childhood, when I was a child and I belonged to a rural area, rural town, so my elders, they used to say, the soil remembers how you treat it. So you all know that even in India, the more than 70% of population, they reside in villages and they are heavily dependent upon the agriculture. So definitely when we talk about green and sustainable agriculture, so we find some kind of connect. And at grassroots level and at local level, and how people, they treat our soil, how they engage themselves with this kind of activity, agriculture. So that's why I remember this particular lesson which we used to get from our elders, that the soil remembers how you treat it. Definitely, when we stand after many decades of that kind of lesson, we got it. So we are seeing some kind of environmental degradation, and we see some kind of food insecurity. So that particular lesson, somehow the words used in those lessons, they echo in the essence of the today's discussion. So definitely I find some kind of connect with this topic. So sustainability is not only a scientific pursuit, but a moral responsibility also. So this is moral responsibility of every citizen. This is moral responsibility of every person to protect, safeguard our motherland, our soil, and our environment. With this note, if I am to raise the concern which I am going to highlight in this particular deliberation, so first of all, I would like to tell you about this relevance of this particular issue. And even when we look at this issue in perspective of the European Union, so we find that the agriculture contributes almost 10% of total EU greenhouse gas emission. So whether it's about the livestock, whether it's about the fertilizer or other sources, major sources, even the agriculture nowadays is responsible for that gas emission, the greenhouse gas emission. So definitely, this agriculture is also a victim of the climate change. We all know about the different kind of challenges which are in the area of or in the sector of agriculture, like drought, like soil degradation, and biodiversity loss. So definitely, these all factors, they have somehow threatened the food security across the world, and in particular, even the Europe. So in Europe also, if you talk about the food security, so these are the various factors, and they are responsible behind that food security. So definitely in this context, so whatever legal framework they have in European Union, what kind of legal framework they have, so definitely that tries to or that aims to make a balance between the productivity and ecological integrity. So both are necessary, both are important. So they must go side by side. And here, if I give you some kind of example, I hope I'm audible to everyone.
Yes, sir, you are audible.
Am I audible?
Yes, sir. Yes, sir. We are listening to you.
Fine. Many times because of technical glitches, a speaker is not audible to the audience. So that's why I have asked this. So, and actually one message is appearing on my screen that internet connectivity is not stable. That's why I asked. So whether I'm audible to you or not. So I want to share one example, particularly the situation in European Union. And here, what happened some 6-7 years back in Spain, so southern Spain, that faced some severe drought. So that reason I have already highlighted the issue of drought. So when Spain faced that severe drought, so instead of traditional irrigation, many people there adopted the water efficient drip system, and that was funded by EU's Common Agriculture Policy (CAP). So this shift was not just technological; it was regulatory and supported by sustainability-linked subsidies. So whenever we are to offer subsidy, whenever we are to offer some kind of technological support, so definitely we must have such kind of legislative framework. We must have some kind of policy so that gives you some kind of support to protect our environment as well, our this land soil as well. So this one incident highlights that how careful the administration in Spain where they provided this kind of support. So this was not just a technological support, as I have highlighted. Rather, it was regulatory also, and that too for sustainability. So sustainability is very essential for protecting and preserving our environment. So here, as I have highlighted about this CAP, so definitely we need to understand something about this CAP. So what this CAP is? So this Common Agricultural Policy (CAP). So definitely since its creation in 1962, where it was originally about the food security and market stability. So for food security and market stability, this CAP got established, got created in the year 1962, and last 2-3 decades, it has evolved towards the greening and linking subsidies to the environmental performances. So definitely these kind of mechanisms have been adopted in European Union, and that is performing well in order to perform this endeavor, whatever endeavor is there towards environmental protection. As far as some reforms which have taken place at uh, European Union level, So definitely, in recent years, the many reforms have been introduced, like eco schemes, which allocate 25% of direct payments to the environmental actions. So, such as carbon farming, agroforestry, and biodiversity enhancement. So, these are the initiatives and the schemes which have been introduced by that CAP also. If I tell you one story, what happened sometimes back. So, a dairy farmer in Ireland, I'm not remembering the name. That farmer once joked that he now has two crops. So people got surprised that what kind of two crops he has, that farmer. So he answered that one is milk, another is carbon. So through a CAP supported ecosystem, actually he planted some kind of native heteros, and that not only suggested carbon but also provided uh, natural facing and pollinator habitats. So his farm became both greener and more profitable. So illustrating that sustainability can be smart economics. So definitely, whenever we are to achieve some kind of goal in order to protect our environment, so we must have this kind of sustainability where we side by side or at the same time we can have a better economics. So both are necessary. So they must go side by side. Another incident that I want to highlight here in this deliberation about the European Green Deal. So that is about the farm to fork strategy. So the farm to fork strategy that got adopted in the year 2020. When it got adopted in the year 2020, so at its heart, it aims about certain things. So what are those things which are aimed by this farm to fork strategy? So that is the Green Deal of Europe. First was 50% reduction in pesticide use by 2030. So you all know that pesticides are good for enhancement in the production, and that's why people they use this pesticide and they want to enhance or they want to have more and more crops and more grains. So definitely, where you want to enhance your productivity and you are making extensive use of some chemicals like pesticides, so definitely it's not good to soil, it's not good to environment. So whenever we talk about the green farming, green agriculture, definitely we are to reduce the uses of that pesticide. So definitely we must have some kind of framework, some kind of legal framework or some kind of policy through which we must be able to reduce that use of the pesticide. So this farm to fork strategy of 2020 of European Union that actually aim to reduce that use of pesticide by 2030, and how much reduction? At least 50% reduction. At the same time, 20% reduction in the fertilizer and 25% of EU farmland under organic farming. So here I tell you that even in India, we have started focusing on this organic farming, and that's why in market. So when you go to any shop, any grocery shop, so you can see two kinds of products. One is the normal product, another is the organic product. So why organic products are also available in that particular shop? Because people are asking or people are making a demand of that organic product. So that's why somehow the aim and objective is to safeguard the environment. That's why many people for their own health and for protection of the environment, they have started consuming organic products. And that's why it motivates organic farming. And that's why people and farmers have started doing this organic farming. Even in the European Union, the aim is to have at least 25% of the farmland land should be used for this organic farming. And once we shift ourselves to that organic farming, and there will be less use of the fertilizer, there will be less use of the pesticide. So definitely it's going to help us in achieving that particular goal, which we have targeted. Now, if I tell you about some incident which have taken place in Europe, and here I am going to give you example of the Denmark. So in Denmark, the under this farm to fork vision, so definitely the highest shares of organic land in Europe you can see in Denmark. So I want to give this example of Denmark. So they have somehow succeeded in that endeavor, and as the goal was 25%, definitely, but so far over 12% of the farmland they have shifted to organic land in Denmark. So definitely this is a very good initiative which has taken place in Denmark. And whenever these kind of initiatives are taken, so through some kind of policy, some kind of better policy, we can support, we can motivate, and these policies may include that tax incentive or a strong consumer awareness. Definitely, these measures would help enhancement in that organic farming. So organic farming is another area in which we can focus and we can have a better environment and better soil. So, but definitely in that case, we can achieve that goal of green agriculture. One more strategy I want to highlight here, and that is adopted, and that strategy is biodiversity strategy for 2030. So this strategy also contemplates the agricultural policy by legally requiring. So legal support must be there. So without a legal support, without some legal framework, it would be very difficult to achieve all such goals. That's why whenever we talk about such strategies, so definitely they must be complemented by agricultural policies. They must be complemented by the legal framework. So this particular biodiversity strategy for 2030, and that legally requiring the restoration of degraded ecosystems and protection of the pollinators. So that is very important. So restoration of degraded ecosystem. So how much loss have already been occurred or have already been taken place. So definitely the time has come to make some kind of restoration of all those degraded ecosystems, and at the same time we are to have the protection of the pollinators. So this way we can have that biodiversity a strategy for 2030, and this is highlighted in that case of European Union. And one more proposal was there, and that proposal was in the form of Nature Restoration Law 2024. And that Nature Restoration Law seeks to restore at least 20% of European Union's land and sea areas by 2030. So when this kind of initiative is there, and the aim is to make a restoration of at least 20% of the EU land and sea area by 2030. So definitely it's going to help us in achieving that particular goal. So it got debated, and when the debate was going on in the European Union, when this kind of debate was going on in the parliament, so they debated this law, and this was as this was termed as the Bees Bill. And this particular Bees Bill, fascinating how a complex legislature text became a rallying cry for the citizens. So definitely a reminder that good laws can also inspire collective imaginations. So when this is a collective effort, collective imagination, so a good law when enacted by a parliament or enacted by legislature, so definitely that can inspire. So different kind of initiatives have been taken place or have been introduced even in European Union, including many legal instruments and mechanisms. So many directives are there, many regulations are there at EU level. So they have introduced different kind of legal instruments and mechanisms in order to have this particular green agriculture and green farming. So as far as our European Union is concerned, because I'm to deliver this lecture in that perspective only, that's why I'm focusing much on European Union. So I may be highlighting something about the Indian context at the end, but as I am highlighting this European Union context, so definitely as far as the legal tools are concerned, so European Union actually uses mainly the two legal tools. First legal tool is in the form of the regulation. So they are directly applicable to all the member states. You all know about the regulations. And second legal tool they have or they use is the directives. So these directives definitely requires the national implementation. So directives are not applicable to all member states. They are required to be implemented by the particular nation. So, as far as regulations are concerned, so CAPS strategic plan regulation, I have already highlighted. As far as directives are concerned, so some kind of directives are there, including water framework directive, uh, that is about the integrated agricultural runoff management. So one more directive got adopted by the EU with regard to this green agriculture. So that is about the sustainable use of pesticide directive. So definitely these regulations and these directives are so helpful and so supportive in order to achieve that particular goal. So some principles have also been adopted by European Union. So farmers must comply with the environmental standards. So different kind of environmental standards are there. So such as maintaining the buffer strips along with the water courses to receive CAP payments. So different kind of principles are there and they are required to be considered and adopted. Now, I'm going to give you one example, and what is highlighted in that example is in European Union country, one country, farmers preserving waterland to protect migratory birds now receive green payments. So the legal compliance thus becomes an ecological partnership. So this kind of initiative is taking place or is happening in some countries of the European Union. So that's also going to support this endeavor or this particular goal. Next point that I want to highlight here is about the uh, market-based legal instruments. So economic legal instruments we call market-based economic instruments. So some kind of frameworks are there and they are market-based. So the first is what? The carbon farming framework. So this proposal was made carbon farming framework. So this is developing a certification system for carbon removal in agriculture and forestry. So if you are able to remove that carbon in agriculture, in forestry, so definitely a kind of reward, a kind of motivation in the form of certification. So that also helps. So when we motivate people, when we support people by giving this kind of certification, this kind of reward, this kind of motivation, so definitely it would be very useful. And this kind of proposal was made, and now people have started accepting this kind of proposal in European Union countries. Some legal recognition is also required to be there about the carbon credits, and that can open new revenue streams for farmers. So carbon credit. So on the basis of both are linked. So on the basis of that certification only, this carbon credit can be offered, or can be this legal recognition can be given to that carbon credit. So definitely it's going to help. It's going to support that particular endeavor. Next part of this market-based legal instrument is the eco-labeling and green public procurement. So eco-labeling and green public procurement. EU regulations, they somehow encourage the labeling schemes. What this scheme does, so this scheme somehow inform the consumers about environmental footprints. So that kind of labeling is made. So definitely one can understand, one can have this information that what kind of environmental footprint is there with regard to this particular product or with regard to this particular thing. So that kind of labeling should be encouraged. So EU regulation somehow encourages this kind of leveling. One more initiative is there, and that is about the public procurement rules. And these public procurement rules allow government to favor sustainable products. So public procurement rules are there, and that allow government to favor the sustainable product. So definitely, it's about making green a market advantage. So how to introduce more and more green products, more and more green agricultural products. So definitely that would be a case of the market advantage. So this is also important aspect that we need to understand. Here, if I give you one particular story, that example, though in France, one bakery, and that advertises that its wheat comes from farms participating in US eco schemes. So suppose this kind of information is given to the consumers. When you start giving this kind of information to the consumer through advertisement, so this one bakery in the France, they advertised, and they proudly advertised. What they advertised? That its wheat comes from farms participating in EU eco schemes. So that somehow began as a compliance label has turned into the marketing identity. So definitely regulation is required. So at the same time, if somebody is able to earn some kind of a reputation on the basis of that regulation, so that would also be a good kind of thing. So why not to encourage people to get some kind of reputation on the basis of a regulation? So as you are participating in some scheme as per the regulation, and now you are proudly focusing on that participation, and you are making your consumer aware, you are making your consumer, you are giving that information, that valuable information to your consumer, that yes, whatever product we have used in this, whatever raw material we have used in this product, so that has come from the farms participating in that particular scheme, and that scheme is good for agriculture, that scheme is good for environment. So definitely, when you are proudly advertising your product by saying this, so you are earning a kind of reputation also. Your product is earning reputation in the market. So there is a linkage between this protection of environment and making some kind of profit and having some place and reputation in the market. So you can have that kind of linkage, and on the basis of that linkage also, we will be able to protect our and safeguard our environment and our farming and our soil and land. So that can also be done. Now, as time is limited, so definitely I am to raise some kind of challenges also, some kind of threats are also there with regard to all such initiatives. And definitely we will have to cope up with all such challenges. We'll have to manage all such challenges so as to improve, enhance the environment protection and safeguard the environment. So at the same time, while implementing all regulations and directives, people have realized that yes, some kind of challenges are also there, and these challenges are somehow in the form of some complexities, and these complexities definitely are required to be removed, are required to be addressed. And one of them is mostly about the small farmers. At big level farming, participating in any scheme, just like I have highlighted about the EU schemes, different kind of EU schemes and policies. So at big level, it's not so difficult, but at a small level, it's very difficult. So I'm trying to highlight about the position of the small farmers. So small farmers, definitely they struggle whenever they participate in all such scheme, because the small farmers, they are having lack of resources, they are having lack of means, they are having lack of measures. So in absence of means and measures, so definitely they struggle at several points. So these struggles in fact somehow enhances their administrative burden. So whenever they are struggling and administrative burden is there, so it's very difficult to get participation, more and more participation from small farmers in all such schemes and policies. So that's a major challenge which I see. Next challenge is that uneven implementation. So if we take example of, even you take example of European Union. So different kind of countries are there in that European Union. Some countries are in east, some countries are in west, and some countries are having more resources, some countries are having less resources. So uneven implementation definitely is a major concern of the European Union, because it has been observed that certain or some Eastern EU members, they lag in enforcing the rules. Particularly, if you remember, I highlighted about the pesticide rule. I highlighted about the uh, other kind of policies and schemes. So whenever it's a matter of, say, for example, a pesticide rule, and some countries, they have adopted it so carefully and they have implemented it so carefully, but some countries, they fail to adopt it. So definitely, this is not going to make that ecological balance. So this uneven implementation is a major challenge. So definitely, EU will have to work on this, and they will have to offer support to all those countries lagging in enforcing those rules and schemes. So countries which are lagging in enforcing rules and schemes, so they should be motivated, they should be supported by other members of the European Union. This way, this challenge can be addressed. Next aspect of this particular challenge is what? So some trade-offs are there, like short-term yields may drop when transitioning to organic farming. So if you remember, I highlighted about shifting to organic farming, and target is set by the European Union that how much farmland should be used for organic farming and by what time to achieve that particular goal. So many countries, they have already achieved. I gave you example of Denmark. So here, definitely this should be achieved. And in that transition period, some kind of challenges are there and they have to be addressed. And without addressing those challenges, this cannot be a possibility. So definitely, when it's a matter of this particular issue, so we can have that EU model, which I have highlighted right now, what kind of mechanism they have and how they are trying to achieve that goal, and how to have that law can be a lever for sustainability. So how law can be instrumental, or law can be just like a lever for sustainability, and it should not be a barrier. So it should not be a barrier. So definitely it integrates the environmental science into agricultural policy, economic incentives into a legal compliance, consumer behavior into environmental governance. So these kind of integration is required to be there, and that is possible with the help of some kind of better legal framework. So that's the major concern. Now, definitely, I am to highlight a little bit about the Indian context, because without highlighting Indian context, definitely it's not good to complete or end up this particular deliberation. So that's why I am willing to highlight some Indian aspects also. Like you all know that we have some policy foundation, we have some constitutional foundation in the form of Article 48A and 51AG. So you all know that 41A and 51AG of Indian Constitution embedded environment protection as a state duty. So definitely this is the responsibility of the state and the responsibility of the citizen as well. So this is about responsibility of both state as well as the citizen. So definitely we have this kind of foundation, this kind of basis. And you all know about the initiatives, the reforms which we have brought, and reform in the form of even the establishment of the National Green Tribunal, NGT. This National Green Tribunal acts as a unique quasi-judicial body enforcing the environmental rights in agricultural related disputes. So whatever disputes are there with regard to farming, agriculture, etc., and environment. So we have this National Green Tribunal, and this is a very unique quasi-judicial body, and that is so powerful, so effective, and it has a great impact with regard to protection of environment is concerned. So in India, we have time to time we adopt certain policies. So in 2007, we adopted a national policy for the farmers, first to include the sustainability, biodiversity, and water use efficiency, as a policy goal. So first time we did it in the year 2007. Thereafter, a national mission was adopted, and this national mission for sustainable agriculture, and this is called as NSMA. So NMSA 2014. So this NMSA 2014 integrates the climate adaptation into agriculture practices, legal foundation under the Environment Protection Act. So this is another initiative which is taken in India. So soil health sector scheme is there. Pesticide management bill got introduced. Organic farming and what we call Paramparagat Krishi Vikas Yojana. So Paramparagat Krishi Vikas Yojana means the customary Krishi development scheme. So this organic farming and this Paramparagat Krishi Vikas Yojana. So that is also another initiative that provides institutional certification under participatory guarantee system. So this kind of initiatives have taken place, and we all know the role which is played by the Supreme Court of India as far as protection of environment is concerned. So they have highlighted different kind of principles, and these principles definitely help a lot in protection of the environment and having that green farming and green agriculture, achieving that particular goal. The principle like polluter pays principle and precautionary principle. So many cases relating to environment protection. So we have done it. So in India, before I conclude my deliberation, I want to highlight one particular incident that has taken place in Sikkim in India. So Sikkim is the state which has become the first fully organic state. So I highlighted that in European Union, people have started achieving some kind of goal, shifting from ordinary farming to organic farming. But in India, we have seen the success story. Sikkim, first fully organic state. And the law was not imposed. Are you getting? So it was co-created by the farmers, the civil society, and the government. They all work together, and on the basis of that, this has been achieved. So definitely, when we have to achieve this kind of goal, so more and more participation from, instead of having a good law, I'm not saying that law is not required. Law is required, but instead of having a good law, better to have more and more participation, more and more awareness among the people, and then only we can achieve this kind of goal. So with this, I am concluding my deliberation. Thank you very much for being a wonderful audience. Thank you so much.
Thank you, sir. Thank you so much. Such thought-provoking and international perspective, particularly in Europe and India, highlights. Next, I am delighted to invite our guest of honor, Professor Dr. Sreenivasulu N, Professor of Law at NUJS Kolkata, to deliver an address on the governance of biotechnology and GMO. Sir, before we proceed with you, may I kindly request my colleagues to introduce you to the audience, then we proceed and hear from you, sir.
Thank you, sir. It's both a privilege and honor to introduce a jurist, scholar, and a global thought leader whose career embodies the perfect blend of academic depth, institutional leadership, and international engagement. Professor Dr. N. Sreenivasulu, Professor of Law at the School of Technology Law, National University of Juridical Science, Kolkata, and a distinguished voice in the field of intellectual property, biotechnology, and technology governance. Professor's professional reach extends far beyond national boundaries. He serves as Distinguished Professor at the Canadian Institute for International Law Expertise, Ontario, Distinguished Member of International Council of Jurists, London, Vice President of the Amicable Court of Earth, Loving Friendly Organization, Japan, and the International Consulate and representatives to the Copyright Society of Uzbekistan. His global engagement reflects a lifelong commitment to advancing the dialogue between law, technology, and ethical innovation. A gold medalist and university first rank holder in law, from Kuvempu University, Karnataka. Sir went on to complete his LLM in Constitutional and Business Law and earned his PhD from the University of Mysuru on Biotechnology and Patent Law, a comparative study of the legal system of United States, European Union, and India. His doctoral thesis was among the earliest in India to explore how patenting life forms challenges a conventional legal and moral framework, a subject that continues to resonate powerfully today. Over his academic career spanning more than 2 decades, he has taught at India's premier law school, including the National Law School of India, University Bengaluru, the NUJS, Kolkata, where he has served as coordinator and head of School of Business Law. He was the founder, chairman of the Department of Studies and Research in Law at Karnataka State Open University, launching India's first LLM specialization in intellectual property and technology in law, a pioneering step in Asia's legal education. Over more than 2 decades, Professor Sreenivasulu Sir has written, edited, or supervised over 100 publications and 20 books, shaping legal thought in biotechnology, intellectual property, and sustainable development. Among his acclaimed international work are Law Relating to Biotechnology by the Oxford University Press 2016, Dynamic Interface of Intellectual Property Law in the Lexis 2017, Law Relating to Intellectual Property in the Lexis 2018, and Human Rights in Development, Penguin Parage, USA 2016. In his national level contribution includes biotechnology and patent laws, patenting living beings in the Manupatra 2018, intellectual property rights in the Regal publication, Law of Plant Varieties, Farmers' Rights, Law of GI and Traditional Knowledge, and the Technology Transfer and IPR, Application of Technology in the Judicial Adjudication in the NUJS 2021. His numerous edited volumes on information technology laws, trade secrets, industrial designs further demonstrates his holistic vision, a world where innovation is guided by ethics, access, and environmental stewardship. Internationally, Sir has represented India on some of the world's most respected platforms, including the World Intellectual Property Organization Conference in Rome, the State Bar of Property Law Munich, where he twice served as a Man Plan Fellow. He was a Scrip Fellow at the University of Edinburgh, Scotland, and has delivered and invited lectures in Germany, Turkey, Malaysia, and Canada. Sir has taken over consultative roles with the Government of India, the West Bengal Biodiversity Board, and the Ministry of Commerce on geographical indication, bioprospecting, and eco-regulatory policy, has directly influenced the nation's legal framework. Sir's global recognition includes the Microsoft Intellectual Property Law Chair Professorship in 2014, the Outstanding Scientist Award in a nomination in Law and IPR in 2015, and his induction as the Global Ambassador for Peace for the Global Forum for Peace and Diplomacy, New Delhi. He has served as editorial board member and peer reviewer for prestigious international journals across USA, UK, Canada, and Europe, as a policy advisor to multiple national law universities and government committees. His body of work reiterates that law must lead science towards humanity and sustainability, not away from it. Please join me in extending a warm and respectful welcome to Professor N.S. Srinivasan. Thank you, sir.
Such a lengthy introduction of mine. I'm very happy to see two of my batchmates in the same screen. Dr. Vanishree, my PG batchmate, and Dr. Benjamin, my PhD batchmate, though very senior to me. Thank you very much for having me today again with Mysore University Law Department and JSS Law College collaboration to have a program on green technology, and green being my favorite color. I'm very happy to debate, deliberate, discuss certain things which are not only connected with agriculture, but as well connected with our Indian culture. More and above that, when this culture is fascinated with some innovation, that results in some technology. And the objective of today's program is to ensure that whatever technology that you come out with for the purpose of promoting agriculture should not harm environment and should result in sustainable agriculture. We all may be knowing, but we might have forgotten that way back in 1960s itself, Government of India launched a green revolution to cater to the growing needs of the population during that time itself. But at that point of time, the technological innovation or technological revolution was not there. It was basically done for the purpose of expanding the lands which are getting cultivated. But of late, from past 2 or 3 decades, what we are witnessing is technological influence in agriculture, especially through biotechnology or such other life science connected technologies, which are trying to not only revamp the agriculture, but redefine the scope and spirit of agriculture. As the students of law, we all know that it is agriculture. It is not industry. It is part of our culture. And as long as it is part of our culture, we consider it as a part of human rights gamut, especially Article 21 or Article 29 and as such. That's the reason why Government of India has not declared or considered agriculture to be an industry. Because in India, agriculture is part of life. It is part of our livelihood. It is part of our lifestyle. Such being the case, how exactly these technological innovations in agriculture can lead to sustainable development is the focal point for today's and tomorrow's deliberations in this program. Green technologies for ensuring sustainable agriculture. Technological innovations which have perhaps redefined not only the field of agriculture, the industry for that matter. Since agriculture is not industry in the Indian legal fraternity related lens, we have to consider agriculture to be a culture, a custom, a practice, part of our lifestyle. And we know it very well that the growing population of this country, which has almost reached now to 150 crores, the kind of cultivation practices that we have been following since ages may not be giving that effective results to cater to the greater hunger needs of the country. In the year 2014, Government of India brought national food security legislation to ensure that there is no hunger deaths in the country, to ensure that hunger needs of the vast population can be met. But that objective is good, but how exactly it can be fulfilled? Whether it is going to be fulfilled by getting along the traditional methods of agriculture, or you need to empower yourself with modern technologies to ensure not only enhanced yield of agriculture, but at the same time ensuring that it is sustainable agriculture. Whether you would like to sustain agriculture or whether you would like to sustain environment. If you would like to sustain agriculture, you would like to ensure that more and more production you would like to envisage, and for that purpose, sometimes you may go for neglecting or giving way for certain mistakes or certain you may reckon with certain problems which may harm the environment, because your motto is to enhance yield. Your motto is to cater to the hunger needs of the population. But when you talk in terms of a sustainable environment, sustaining the environment, sustaining biodiversity, ensuring the maintenance or equilibrium of environment or climate, in such scenarios, whatever technology that you come out with for practicing agriculture, or whatever customary practices, traditional practices that you follow for the purpose of practicing agriculture should not harm the environment. I'll give an example here. 15 years back in USA, as we all know that in USA, 70% of agriculture is biotechnology based, genetically modified way they go about. Unlike European Union, which is very traditional or conservative in terms of accepting modern technology. So they're very cautious. And India tries to play in between. We are both cautious and at the same time, we would like to ensure that the yield is more so that the mass population can be fed. So it so happened in 2005 in USA, wherein one corporate farmer was practicing genetically modified farming or non-organic farming or biotechnology farming, whatever you call it is. It's a celebrated case. Even if you can Google it, you will get it. The case is titled as Monarch butterfly. Monarch butterfly case. If you type in Google, you will get the entire detail. It's a case of monarch butterflies. These butterflies, as we know, they survive by eating small insects. One fine day in 2005, around biotechnology-driven agrarian lands, people noticed that these butterflies, a type of butterflies which are given the title monarch, these butterflies are disappearing. Season by season, the number is coming down, and more or less got extinguished. Remember, it is happening around biotechnology-driven or genetically modified plantations or whatsoever, not organic farming. So when the inquiry was conducted, the results came out. The reason was that the food of butterflies, that is small insects, which were eating the proceeds of this genetically modified plants or genetically modified crops. I mentioned this is happening around genetically modified farming lands. So the small insects which the butterflies consume for survival, these small insects were eating the proceeds of genetically modified agrarian lands. Maybe genetically modified plants, crops, leaves or seeds or whatever. And now these butterflies are consuming these insects which have eaten genetically modified farming lands proceeds. That is the reason why these butterflies are getting extinct. That means genetically modified farming or genetically modified food, as per our consumer law, is not only going to be harmful for a sect of human beings, it is also harmful for the greater environment, the wildlife, the biodiversity, right? Why insects, whichever insect for that matter, which happen to eat the proceeds of that genetically modified crops, seeds or whatever, they could not digest those proceeds. And as a matter of fact, when the same insect was eaten by the butterflies, they could not digest. That's the reason why the butterflies are getting extinguished. So this is one alarming thing that we need to keep in mind, that whatever technology that we come out with for spearheading agriculture, for enhancing the yield in agriculture, for catering to the hunger needs of the mass population, whatever, right? If it is causing harm to the environment, if it is disturbing the ecological balance, it is disturbing other biodiversity species, it is not going to be considered as green technology. It is still used with reference to green revolution only, agriculture, green. But the technology that you have developed is not going to be suitable for maintaining the sustenance of the environment. And this kind of practice is not going to be considered as sustainable agriculture. That's why I said, whether the argument is meant for sustainable agriculture or it is meant for sustainable environment and biodiversity. It so happens that our nature, the Mother Earth, has got its own cycle, wherein some small insects become food for bigger insects, and that cycle goes on, and that's how you maintain biodiversity. And in especially in forests and all, because the presence of a lion makes that required balance to be ensure in that forest or whatsoever. In the high seas also, the presence of dinosaurs or big fishes and all, they ensure the maintenance of that balance. So what I'm trying to say is, whatever may be the innovative technique that we follow, our intellectual property law may facilitate patenting, facilitate GI production, geographical indication production in case of agricultural and natural goods. Our plant variety system may spearhead promoting, protecting not only agrarian innovation, even farming innovation also, traditional farmers innovations also, right? So we have this structure available, platform set for promoting whatever type of innovations that are coming from the field of agriculture, as long as they are innovative, as long as they are useful to the mankind. But we are forgetting the fact that not only human being is present in this, earth, on this earth, being part of the nature, there are other living entities which are also part of this environment or this nature, whatever you call it as. But this agriculture is basically meant for you and me, human beings, more or less. But the environment, it is housing umpteen number of living entities. So the practices that you develop, the technologies that you develop, the practices that you follow for ensuring the growth of agriculture, enhancing the yield of agriculture, if it is resulting in disturbing the climate, disturbing the ecology, disturbing other species, it may be called as a sustainable agriculture, but it cannot be called as the agricultural practices which can sustain the ecological balance, agricultural practices which can sustain biodiversity or broadly the environment, right? But what happens in general, we try to give more impetus for the needs of the human race, human being, right? We need to cater to the staple meal for each and every human being. And for that reason, that the only option, probably the substantial amount of people, since they are vegetarian on this planet, so the only option is to increase your yield in the agrarian lands or the cropping, whatever you are going with. Whether it can be done with organic farming in the sense of by following traditional methods, or it can be done with deploying modern day technological tools, including genetic modification, recombinant DNA technology, or such other biotechnological modes by virtue of which you can not only engineer the crop, but you can ensure that the crop is giving you more and more yield, and sometimes the crop can give you better nutritional values, right? So we are trying for ensuring not only high yield in the agricultural sector, but as well we are trying to ensure that the select crop contains more and more nutritional values. In pursuit of this, more yield, more nutritional values, are we sacrificing, are we succumbing to pressure and ensuring imbalance of the ecology, imbalance of the biodiversity? If that is the case, you cannot call that particular practice as a sustainable practices of agriculture with reference to environment. And even strictly speaking, the modern day practices of agriculture, especially when it is getting through biotechnological innovations and all, right? Though it may be giving you better yield, more yield, but it is having greater impact on the environment. The example that I gave you, monarch butterfly is a case where, in pursuit of human being to get more yield, better yield, you have killed one particular species. Almost that species was about to be getting extinguished. So that imbalance is happening, right? I agree. Any technology for that matter will have its own bad effects, its own disadvantages and all. And we need to arrive at that equilibrium and balance. And that is what the job of law. I believe my other colleagues, who are going to be part of this program for today and tomorrow, they know better than we law people with reference to the kind of practices they follow, the kind of technological tools that they come out with for ensuring growth in agriculture, right? They may say sustainable yield, sustainable growth, but what we want as a lawyer or people from field of law, whether it is really sustainable agriculture, ensuring sustainable environment, right? So with this briefing, perhaps since my talk is titled to be biotechnology, GMO, and sustainable agriculture, I'll try to do justice to that title as well. Because I'm the second speaker, I thought of taking the general overview of the program of today's and tomorrow's as well. So, as I briefly mentioned previously, biotechnology is giving a lot of scope, a lot of momentum, a lot of impetus, not only for agriculture, most of the modern days industries also. But when it comes to agriculture, biotechnological applications are given more importance because we need to cater to hunger needs of the masses. And as far as India is concerned, 60% of biotechnology industry applications are going into agriculture. Of course, we have seen BT cotton debacle, We have seen BT rice debacle in the early 2000s, especially in and around Maharashtra. We have seen a BT brinjal fiasco in 2012 when farmers protested against these biotechnologically driven crops, saying that it is nothing but creating unnecessary competition. It is nothing but doing away with organic farming. It is nothing but introducing technology which is not tested. It is nothing but without building capacity, throwing us into some danger zone. A lot of social, legal, environmental, health-related issues were brought in, right? And largely it is nothing but sustainable development. For ensuring sustainable development of the mankind, the entire society, the country for that matter, whatever modern technologies that you bring in, for that you need to build capacity. You need to ensure that there is no risk, harm, which is associated with it. In case of any damage, harm, or injury, how exactly you are prepared to undo it, right? How exactly you are trained yourself, your technological industry, how exactly our farmer or farming folks are empowered or are energized, how exactly their skill is developed, how they have been trained, oriented towards these new technologies. Beyond talking about ensuring sustainable agriculture, how exactly we have built our capacity, whether our farming folks are skilled enough to put their hands on this technology, right? Without testing that out, of course, the government of India during that time launched these BT cotton, BT rice, and also BT brinjal and stuff like that. There again, the broader question that came out because of those agitations, protests, and all, which took place during that time, the basic focal point was sustainable development. For the purpose of ensuring sustainable development, how exactly you have built the capacity? Agree, you are trying to introduce modern technologies, right, which may be green or not, the time will tell, the law, application of law will tell, to enhance yield, to cater to food needs. But while supplying food, are you harming the health of that individual? You are giving genetically modified food, you are giving non-organic food, you are supplying genetically modified crops and its proceeds for human consumption. Whether such kind of food is going to be not harmful, like what happened in case of monarch butterfly example that I gave you. If it is harmful, how exactly your food safety and the standards authority of India is permitting them? If it is harmful, can you go and invoke the provisions of your consumer law, saying that it's a consumer grievance, I have consumed genetically modified food, it was not properly tested, we don't have the capacity built, and marketing permission has been given because of the WTO compulsion whatsoever, right? Because of international mandates and all. So you have made my life to be an experiment in the laboratory of a scientist, right? My stomach has become your experimental lab, right? Without testing it out, you have made me to consume that genetically modified food. It may be BT rice, BT soybean, BT brinjal, BT tomato, whatever. I happen to eat it. Now I have health issues. So the fact that you are trying to cater to right to food of few people, or ensuring food security, promoting agriculture, should not result in damaging the health of the people. The food that you consume should not damage your guts, right? Intestines, like it happened in case of monarch butterfly case. And I'll give you one more example. In the voyage of promoting technologically driven agriculture, sometimes what and all is happening, and we are unable to take note of it. Like monarch butterfly, this again it happened in USA only. You must be knowing about this Monsanto company. Now in India, Mahiko was the topmost agricultural company at one point of time. Monsanto across the globe, it's superpower, number one agricultural company. Now it has taken over our Indian Mahiko also. Near Bangalore, they have very huge, thousands of acres of plant they have, Monsanto people. That's a base for them in India. The point that I'm trying to put across is, in the later part of 90s, you can say around 2000, change of millennium when it was happening. This Monsanto company happened to come out with the Terminator technology. Terminator technology they used with reference to agriculture only, right? You all know that during the same point of time, Hollywood was coming out with Terminator 1, Terminator 2 kind of movies and all, right? Action movies and all. During the same time, Monsanto came out with this technology, Terminator technology. What it is? If Terminator, by using Terminator technology, that plant's capacity to get resowed was terminated, right? That plant's capacity to generate next generation was terminated. In the sense, for example, you have gone for, say, BT tomato, based upon supplied to you by seeds of those that plant were supplied to you by Monsanto, and Monsanto deployed that Terminator technology in that plant, genetically modified tomato plant. You have sowed it; it has given you yield. That yield you can consume and eat. That yield you cannot again use it for resowing. It won't grow. That's what next generation, giving birth to next generation, was terminated. So that you will again go back to Monsanto company only in next season. After Kharif, after Rabi, right? Whatever monsoon, winter season you call it as, you have to again and again go back to Monsanto company only to purchase seeds. That was their funda. Every 6 months, the farmers should go back to them to purchase seeds so that they can make money. Because the seeds that they supply will grow, but the same seeds cannot be used for resowing. Only one consumption, then that's it. See, this kind of draconian techniques also were brought by biotechnology or biotechnology companies, and which are not only harming our traditional farmers, and they're making the traditional farmers to become slaves of corporate seed companies. And of course, we have completely prohibited it. Our in India, the Plant Varieties and the Farmers' Rights Protection Act categorically says that the Terminator technology kind of innovations are prohibited. Prohibited from intellectual property monopoly, and also prohibited from being practiced, cultivated, used in the Indian agrarian lands. So now I have given you two different examples. One is monarch butterfly. The second one is the Terminator technology. Two different extremes, two different problems that your biotechnology tools may throw open, especially in the agricultural field. If you are looking for sustainable agriculture, if you would like to enhance only the yield and supply food to the masses, forget about whether your seeds are having the capacity to get resowed or regrow. As long as you are getting more and more yield, you will be happy, right? If same Monsanto supplied rice, wheat, or whichever, whatever it could be, irrespective of the fact that every season you have to go back to Monsanto only to purchase the seeds, doesn't matter for you. You will say, I'm getting better yield than the normal seeds, so that is what I want. So I will sell this more seeds, more and more yield, whatever I'm getting, I will make money. And some amount of money I will shell out for purchasing seeds again by going back to Monsanto company, right? So this is nothing but taking control of your agrarian folks or agrarian economy. And the other example that I gave you, damaging the environment, monarch butterfly, damaging the species, damaging the ecological balance or biodiversity, right? So these two extremes are there as part of modern day technological developments, especially when it is connected with the biotechnology and agriculture. So the best practice that we should follow, or we could follow, because we are talking in terms of maintaining that social legal order, right? Social legal order while promoting technologies in agriculture, especially because agriculture is supplying the staple food to you. Without that, nobody can survive. Your right to food, right to life, everything is interconnected over there. And that's the reason why agriculture is not considered to be an industry. You may be having 100 acres, but no income tax to you because you are not industry, right? And it is a culture. It is not industry. It is not a profession. It's culture. It's part of your life or lifestyle, whatever. So because of all these reasons, we have given a separate treatment, especially when it comes to India. We have given a separate status to agriculture. And we need to maintain that status as well. Unlike USA, in USA, they go for corporate farming, right? And even they allow patenting of new plants, plant innovations, agricultural methods, plant varieties. All those are amenable for corporate monopoly over there. But in India, we do not allow agricultural methods to be patented. We do not allow typical agri-innovations to be patented if it is required for public purpose. Only in exceptional cases we allow. And our plant variety law categorically says that we promote not only plant innovations, but as well we promote farmers' innovations as well. Farming folks can also come out with their own methods, whatever they are practicing from ages, they can innovate, they can modernize, right? These crossing, budding, all these techniques that our farming folks have come out with, it is their own innovation. They have not learned the same from any university or laboratory and all that. It is part of their traditional knowledge. And we all know that, especially when it comes to traditional knowledge of farmers, it is nothing but the knowledge by virtue of which they get closer to the nature, observing the nature and using the nature to cater to your needs. That is part of the traditional knowledge. And by virtue of that, you are making your life fruitful. By using that, you have nurtured or modeled your life. And as a result of which, you call agriculture, not cultivation, right? In other countries and all, substantially they use the word cultivation. We use agriculture, culture. It is a culture, part of human rights, not part of commercial monopoly whatsoever. So the point that I'm trying to put across, when you are envisaging for sustainable agriculture through traditional methods of farming, organic farming, or by deploying modern based technological tools, including biotechnological tools, because now aftermath of globalization, which started in 95, any technological development, any type of innovation, irrespective of the discipline, irrespective of the industry, irrespective of the country, all the 222 countries are supposed to promote, incentivize, reward, grant patent, grant geographical indications protection, or grant plant variety protection, whatever. You have to promote technology, whatever may be the field where the technology is going to be applied, used, or implemented. That mandate you have already from past 3 decades. But what we have to look at is, as legal folks, whether that general rule has got any exception, right? Sometimes exception will have a larger interest, larger purpose to be served than that of the general rule. Like, for example, like it happened in case of COVID. Government of India declared that whatever may be it is connected with COVID, it may be capsule, it may be injection or whatever, we will not grant any commercial private monopoly, no patent whatsoever. And we proposed to the WTO, WIPO also, they also accepted because of emergency or exigency. Similarly, when it comes to agricultural field also, though we are allowing some amount of minimal patent grant, some amount of plant variety innovation grant and all, in case of public need, Government of India has always keeps its control over such a private commercial monopoly to ensure that the public demand, public interest is better served. At the same time, while allowing this kind of private monopoly commercialization and all that, keeping in mind the 2 examples that I gave you, monarch butterfly and Terminator technology, right, which are literally prohibited from not only practice but as well commercialization in India. But Terminator technology is not prohibited in USA. It is they have no problem with that. But we and European Union, which as I mentioned, European Union is little conservative when it comes to doing away with the traditional modes and adopting modern technologies, right? So we are in between. Sometimes we would like to go with the technology, modern technology. We say that we have mass population, we cannot stick to traditional means and modes because we need to cater to 150 crores. And sometimes we say, no, like European Union, we are also subcontinent. We need to have a very good amount of traditional knowledge. Our farming folks are naturally skilled. So this also we do, that also we need to do. Our situation is like that, right? We cannot take one path completely, right? Such being the case, right? When we envisage for sustainable agriculture, especially in the era driven by technology, especially biotechnology, which is lamenting across the globe in terms of its application when it comes to agriculture, especially to enhance yield, to ensure better nutritional values and all that. we need to ensure that it doesn't have any environmental hazards associated with it. It doesn't injure or it doesn't damage other species. It doesn't disturb the maintained ecological balance. And it is not done with an intention to make our agrarian folks to be slaves, like it happened in case of the Monsanto case that I mentioned. So that's why the first the question that I asked in general, whether it is sustainable agriculture or it is sustainable environment that you are trying to envisage when it comes to green technology, because green technology is a very, very big term. Not only agriculture would get into it, energy will also go into it and all that. So green usage of green technologies or promoting of green technologies in the agricultural field, whether it is ensuring growth of agriculture, better yield in agriculture, and at the same time, sustainable agriculture. You would like to sustain agriculture, or you would like to sustain traditional knowledge, you would like to sustain environmental balance, or you would like to sustain the species equilibrium in this Mother Earth. So these things we need to debate, deliberate, and take ourselves forward from the lens of the law, especially when our agrarian scientists or agrarian folks, they come out with better innovations, more and more innovations, which are technically very, very sound, very, very skillful. They are capable of giving you better yield and all that. And there are all number of positives in terms of science and technology. And in terms of law, because we need to look at the society at large, we need to look at the environment and all that. So we always go for taking all those points which are the cons, right? So we need to arrive at that equal balance between the pros that our scientific folks project and the cons or the demerits, whatever our society would have as a matter of fear, as a matter of apprehension, reservation, concern, whatever it is. So while trying to ensure sustainable agriculture in the background of modern day technologies, you can call those technologies as green technologies only when they are ensuring not only the better yield, highly caloried food, but as well not disturbing the ecological balance, maintaining the environmental security and sustenance. So with these words, I stop here, and I thank my colleagues, in particular my senior Professor Benjamin, for giving me this opportunity, and all young colleagues who are part of this program, hosting me and all. And once again, I congratulate Mysore University for hosting this kind of program. I think more than 180 participants we have reached, and people from different parts of the world have logged in. So Mysore University has become global under the leadership of the law department, and in particular Professor Benjamin, and supported by youngsters like Kudrat and all that. Wish you all the best. Thank you very much.
Thank you, sir. Thank you so much for your comprehensive and insightful and GMO policy-rich discussion. Next, I'm honored to invite our distinguished speaker, Professor Dr. M. Vishwanath, Professor, Dean, Chairman, Faculty of Law, Karnataka University, Dharwad, to share his insight on intellectual property rights and technology transfer in agri-innovation. Before starting the virtual stage, we would like to introduce sir to the audience. May I kindly request Ms. Ghana to introduce her to the audience.
Thank you, sir. It gives me immense pleasure to introduce a remarkable academician and visionary legal scholar, Professor Vishwanath M., Senior Professor, Dean of the Faculty of Law, and Chairman of the PG Department of Studies in Law at Karnataka University, Dharwad. Professor Vishwanath completed his law graduation in 1998 and obtained his master's degree in criminal law from University Law College, Bangalore University in 2000. He went on to pursue his doctoral research at Karnataka University, where he earned his PhD in law in 2010 on the significant topic, a critical study of legal control of organized crime in India. An academic of rare distinction, Professor Vishwanath has been teaching law for over 25 years, shaping generations of legal scholars and practitioners. His academic journey began as a lecturer at KLE's Law College, Bangalore, followed by VM Salgokar College of Law, Panaji, and University College of Law, Dharwad. His administrative acumen is equally noteworthy. He has served as Registrar of Raichur University from 2021 to 2024 and has held several key academic governance positions, including syndicate member, academic council member, and Dean of the Faculty of Law at Karnataka University. He also briefly held the distinguished position of Acting Vice Chancellor of Karnataka University, Dharwad, a testament to the university's confidence in his leadership and vision. Professor Vishwanath's international academic engagement includes his tenure as the Dr. D.C. Parvati Visiting Fellow at the Department of Politics and International Studies and the Center for Governance and Human Rights at the University of Cambridge, United Kingdom in 2011. During his fellowship, he was associate with the Sydney Sussex College, Cambridge, where his research focused on human rights and governance in connection with dams and displacement, a subject that bridges law, policy, and social justice. A dedicated teacher and prolific scholar, Professor Vishwanath has authored and edited significant academic works, including his monograph titled Development-Induced Project at the Cost of Human Rights, An Error Irretrievable, published by the Dr. D.C. Parvati Foundation, and the edited volume, Majesty of Law. His research interests span environmental law, human rights, business law, jurisprudence, comparative public law, and criminal justice. He has guided 9 doctoral scholars and continues to mentor many more who are pursuing research under his supervision. His extensive body of work includes over 25 publications in reputed national and international journals and edited volumes, addressing pressing contemporary issues in environmental law, human rights, and criminal law. Beyond teaching and research, Professor Vishwanath has served on numerous academic and administrative bodies, from boards of studies, boards of appointment, and department research committees to IQAC and peer review committees, playing a vital role in shaping academic quality and institutional governances across universities. Today, we are truly privileged to have Professor Vishwanath with us to share his insights on intellectual property rights and technology transfer in agriculture, a topic that lies at the intersection of innovation, sustainability, and legal policy. Please join me in extending a warm and respectful welcome to Professor Vishwanath M., and we look forward to his enlightening.
Thank you. At the outset, I'd like to thank my good friend, Professor Benjamin, the Dean, Faculty of Law, and the Chairman of the department, and also the Principal and the staff of JSS Autonomous College, Mysore, for providing me this opportunity. Well, we listened to 2 of the wonderful speakers who spoke on various aspects of agriculture and IPR and also the challenges that we face. So I just prepared a few slides so that we can move on the slides to look into what are the issues probably that I like to address and the challenges that we face, especially when it comes into the context of the IPR and technology transfer in agri-innovation. I am basically a non-IPR man because I strongly feel that IPR does not synchronize as well with the welfare state context or on the rightful note of the equilibrium of a society. But still, as a law professor, as a law student, I owe that IPR is a very challenging and the required composition for any student because it gives us how the intellectual context will make us much more competent, viable, and also provides an edge over the others. Next slide, please. Yeah, it's incidental that wherever I go, my first slide starts with a tribute to the farmer, and we are talking about the farmers' issues connected with the IPR because the earlier speaker, Professor Sreenivasulu, clearly mentioned that it's a culture, and the culture is sown by the human, that is the farmer. So without him, we are nobody because we are all surviving on whatever he produces. In India, we tell Annadata Sukhi Bhava, let whoever feeds us be happy. Next slide, please. Yeah, as I told, welfare state. Now, a professor from Delhi University made a point that it is something moral that we are supposed to look into. And that is what the welfare state also actually means for us, based on the principles of equal opportunity, equitable distribution of wealth, and public responsibility for those unable to avail themselves to the minimum provisions of a good life. Now, I just want to emphasize on this public responsibility that we all owe to the farmers, because I strongly believe that they are the one who are unable to avail themselves anything that actually they deserve it. Okay, so it becomes every individual responsibility to see that this farming community are protected and also elevated. Okay, to see that their lives are much better as what is promised in the constitution and the concept of the welfare state. Next slide, please. IPR and agriculture, as it is basically two different parts, maybe north and south, but of course it is supposed, because if you look into the east and west, the sun rises and it should set. Okay, so there is no chance of missing things. So whether you like it or not, these things do encompass us on many ways. And IPR is one which connects the agriculture. So IPR agree is contentious between developed and developing and underdeveloped nations. And it was very clearly made by the earlier speaker, telling that how US has been adopting itself or adopted nearly 70% to the BT, and Europe is quite apprehensive, and India is also having a mixed reaction. So in this meal, whatever connected with this IPR context, we believe that it is contentious, especially the scale of the benefits is far higher to the developed countries than compared to the developing or undeveloped countries. Farming is basically based on shared knowledge and resources. And IPR is basically a commercial venture assuring exclusivity. So how do you break this context or mix this context or match this context of something where you have got something shared knowledge and where you have got exclusivity? And this is the context of IPR, because you want to commercialize your intellectual properties. So that is how this context will benefit, okay, in one way. And in the other way, you tell no, it restricts that how the farming culture, the farming traditions are practiced, especially in the developing countries. So it is often accused that IPR limits farmer traditional rights. It is accused that no, if you're going to do this, it is going to definitely bring in, okay, certain restrictions or take away the rights of the farming community. We'll all look into see. I got so many things to discuss on that matter. But it is also necessary that science and agriculture should move coordinately for sustainable environment, economy, and food safety or security. That is for sure. Okay. So it clearly indicates that we are supposed to move in a sustainable way. And of course, the questions that came up earlier, whether it's sustainable environment or sustainable agriculture, and also I would add whether it's sustainable economy to move in. Okay, so these questions are definitely up to us, okay, for discussion. Next slide, please. So IPR grants inventors and creators exclusive rights over their new technology, processes, and products for a limited time. Of course, time frame. I'm not going into the IPR in detail. You all know better than me the IPRs. One context is in agriculture, these rights protect innovations across the entire value chain. Now, that is what the apprehension is. It's not only one part, it goes into the chain, value chain, maybe probably from sowing to that of the markets. This innovative context comes into picture, and this is where it becomes a bit misty to see whether it's going clearly in what direction. Okay. So, of course, patent laws are invaluable in the biotechnological sector, especially in the US, Europe, and Japan. However, there is a need to expand the scope of the technical knowledge and its utility across the other parts of the world. This is the point that probably we should deliberate, because we are looking into the context where, when it comes into the IPR, maybe patenting, maybe trademark, or any other, especially into the plant varieties, the seeds. So we are with this apprehension that how we can match up things or how do we compromise on certain issues for the betterment, or how do we definitely have an edge telling that this would lead into this context, as what earlier it was stating that can they experiment on my body for their benefits? That's the question that what I think we should all try to look into. Next slide, please. Agri innovation like patents, uh, maybe it's not exhaustive. I had just brought in certain things, maybe dropped in with certain things what I read across. New breeding techniques is one point that basically we look into, because this breeding techniques is what we normally want, because we need food security. The food security context evolves around what is the storage of food that we have to feed to this 7.5 billion population that we have across the globe. And when it comes zero downs to these nation states, they look into their population. And this new breeding techniques will always, as they told that in India in 1960, we came up with a certain context of green revolution. And green revolution definitely involved something, some breed where it yielded more crop. And for example, if in 1 acre, if somebody was to grow maybe 20 or 2 quintals or 2 tons of wheat, it raised to 12 tons of wheat. Okay, so the context is simple, that we need some new breeding techniques maybe to fulfill the mouths that we are supposed to feed. So GM traits, that is genetically modified traits, are all trying to put it across. Okay, so the point is very clear that we are very apprehensive regarding this genetically modified traits, whatever it is, especially into the consumable things that what we are looking into. Agrochemical formations, obviously, in the first session, the speaker was talking about the fertilizers. Okay, it has so many things, including the pesticides, the chemicals that we are trying to put into, believing that it can yield us better things. The farm machinery is obviously something very technical and also involves so many things. Of course, in the context, if you take a country like India, the farm machineries are quite restrictive because of the physical structure what we have, and the farm holding that what the farmers hold, then compared to Europe, especially US or Canada, for that sake, which are huge in nature. And farm machineries in those contexts are entirely different when it comes into the context of the subcontinent or the South Asian region of this continent, or including the African continent. And of course, digital agri software devices all do come with the patenting, because somebody has invented and it goes with the patent. And this is how that new innovation comes connected to the agri field. Next slide, please. Of course, this is one contention issue, that India is one country which has come up with a law way back 25 years back. I think somebody can definitely look into it. The journey of this plant variety farmers' rights, okay, especially connected with this. I would try to pause here and tell, especially the people sitting across in Mysore. There was a great professor, C.K.N. Raja. Everybody knows Professor C.K.N. Raja. When these things were emerging, especially plant varieties was emerging, and a professor like the caliber of Professor Raja came out with an example. Till today, I remember that, because we keep on discussing that point, that the neem came out, that somebody has transformed that into a right because they have find out something unique, and they wanted an IPR right, and it was granted. He has written a story that how the IPR can be troublesome in a very, what you call, in a rustic way of what the layman thinks. So one man got up early in the morning, went near the neem tree, took a stick of a neem tree and started to brush. Suddenly a policeman comes and catches him. And he is so scared at what he did. And the policeman tells that you infringed somebody's patent right, that you are using a stick, a neem stick, which has been already taken by somebody. So it is something so shocking to him. And look, this may look very funny for us, but what has been told 30 years back by professor in a story, maybe it may look real today. We don't know, because we believe that what is found in the nature belongs to all of us. But none of us probably know that, who knows whose right it has become in what way. And this particular plant builder's right or plant variety protection right has always been contentious, and it will remain so because it has both benefits as well as its own loopholes. Okay. So especially the farming sector and their intellectual capabilities, their awareness is always a restriction when it comes to it. New plant varieties that are distinct, uniform, and stable means these are all things that can be patented. That's why I highlighted these things. Now, your plant builder's right grants exclusive rights to commercialize the propagating materials, seeds, cutting, all those things have become a bit exclusive. Probably we have forgotten that the farmer who used to take up his old bag, which was kept last year from the particular cultivation, what he has done, and use it again. Now, the present situation that is so apprehensive that probably he cannot use it because it has been taken by somebody else, adding something to it and getting some right. So that is where the farmers are probably not able to get what actually is their basic right, that there is no need to money to get the seeds, but he is forced to go to the market for various reasons. And of course, the varieties also have changed, and we should go with the cutting edge context also. Next slide, please. A trademark. So the patents is one side, which is of 20 years and all technical parts. I will not go into it. But a trademark context is, it has its own way of marking and telling that this is what we are. Protect brands, names, logos on seeds, food products, fertilizers. One way it is good that people know what to buy. That's why it tells customer or consumer can identify and choose based on the source, reputation, and quality. Okay, I'm more clear that if I want to buy a pen or something, I would normally go into a pencil. I want to buy of what particular company it is because I believe that the pencil would give me the result what I'm expecting. And same thing happens with somebody who wants to grow something. If somebody wants to grow a tomato or a potato or something like that, he always believed that this seed would lead us into a better thing. And it is also not only with seeds, it may be anything. It may be fertilizer, pesticides, so many things. Okay, so it depends upon what source it is on the brand, its reputation and quality. That's where the trademark comes into picture in this agri innovation. Next slide, please. Trade secrets, obviously, that is how it is maintained. None of us know what is happening in KFC, but everybody wants. None of us know what's happening in McDonald's, but everybody wants. So they are that secret. Okay, so there are certain things that are required to be kept secret because it is the ethics that normally comes up into picture. So they protect confidentially proprietary information, specific in-house breeding protocols, software algorithms, and other processing methods. Exactly, the company gets a competitive edge in the market. Okay, so that is how things move. Okay, so look, this trade secret doesn't mean that it is something like somebody puts up an WhatsApp message and tells the Coca-Cola's trade secret has been revealed for so and so. Somebody has kept it in the American banks, all those things. But I still don't believe that the Coke's recipe of the secrets, what they're carrying on, is available publicly. I don't believe so, neither this Coke or Pepsi, because they have that context of maintaining the secrecy. That's how things move. And when it comes into this context of agriculture, this also holds good, okay, for the company and also even for the farming community. Next slide, please. Yeah. Digital world. This I want to make it clear. Even I was new to it when I was just searching across. Look how things we learn together. Okay. This is what happens. Digitalization often refers to the increasing intensity of human computer or human information and communication technology. That is ICT interactions. Okay, we all know today, we all push our students to use the technology better. And Professor Benjamin knows that how university expects us to use the ICTs. Okay. In the same context, we are trying to push into the agricultural field. How good it is. Till today, I can bet that most of the teachers at the university level are still not comfortable in using ICTs. Okay. So digitization and digitalization. Okay. So digitization is different from digitalization, which can mean changing component parts from manual to digital. So let us be clear that this digital world does not make everything digital. We are trying to make it digitization and digitalization. Okay. Now, for example, it said agriculture digitalization involves the development, adoption, and improvement of digital technologies in agricultural sector. Now, how it happens? Now, very simple. The second point on the screen clearly indicated changing the component parts from manual to digital. That is the context. Now, everybody sitting over carry a smartphone, and we all believe that we are smarter than the smartphone, but we are not. The smartphone is much smarter than us because it is feeded with all the information, and it probably grows. Okay. We have a weather report on our mobile phones. Immediately, if I show you, it tells, okay, so we have this weather indicator telling that what would be the weather condition today in your place. It's quite simple for us, okay, to know. So literally in Dharwad, what is the weather? So I have this. So if I want this information, probably I should call to the Agriculture University of Dharwad to ask that what would be the chances of rain today or tomorrow in Dharwad, because they are the one who take up this information and send up to the press. Now it is not so. It has been digitalized. Okay. So what are these hard things have become today digitalized? So this digital world is so simple that from manual it has become digital context. Now, this is how probably we see that things may be beneficial. These innovative things may be beneficial, but only thing is how do we put into use and how probably we execute things. Next slide, please. Yeah. Now, coming to the core context of technological transfer, what actually it means. This definition definitely it comes from the IAA. Technological transfer in agri-innovation is the process by which protected technology. Look at the word protected technology. That means IPR is involved in this. Maybe it's patent, trademark, trade secret, like a new seed trade or a precision agriculture. Maybe sensor digital tools moves from the creator. The word that it uses university or a biotech bar IT firm to the users. That is the seed companies, extension service, and eventually farmers. But I just wanted this to be reversed. Okay. There are two reasons. Number one, when you tell that this particular technology is created by whom? It tells number one, university. Okay. I believe strongly that throughout the globe, there are agriculture universities which is being given paramount importance, And I'm lucky enough to have an agri university in my place and many visits to there. And I've been also faculty over there as a visiting faculty. I understand what efforts all the agriculture scientists put over there to see that they come something new every day to benefit the farming community of this country and across the globe. Okay. So that's why it tells university, because it is common, as the earlier speaker stated, that this should be general in nature. Okay. This cannot be something based like a private proposition. No, it should be a public proposition. So university. Now, biotech. Okay. Now, the Karnataka, especially Bangalore, is known, okay, for this biotech company. Okay, everybody knows across. Okay, they have been doing wonderful things. Okay, so they get involved into it. Maybe IT firms. It's not only connected, only providing service to only those who look up high. No, it involves everything, because they just want to provide some technological development which converts that into commercial angle. They are beneficiaries of it. So from them, it goes to the users. So, for example, little seed companies. Now, this is the point. Now, my point context is when it is created in a university, should it go to the farmer first, or should it go to the company first? Here, there is a dilemma, especially because anything that is put into use, there is something called as a precautionary principle. Okay, until you take up a precaution principle, you cannot put into the use. Now, for example, human medicine, the medical trial should take place, know the results, then put on. The earlier discussion was COVID was a part and medicine. Okay, I strongly believe that the COVID was not tested on humans accurately. That's not what I believe. Okay, maybe others have different opinions, but I strongly believe that they were in a hurry to put it across because it was a global pandemic. So what to do? Maybe they had come out with that. We don't know. We are all being injected. I don't know what we become later, maybe 10 years down the line, what it would be. So if the same thing goes ahead with this context of creation by an university, probably they would test that into a better, who is professional, whose labs are quite up to the mark. Okay, maybe a 5-star lab which goes into this, okay, looks into its impact, then moves up. So that is where this combination of agri universities and the companies grow more, and they are always into an agreements or MOUs of probably disseminating this kind of information so that will be benefit. I'm not telling it is right or wrong, but definitely it should be in a middle path to benefit both. Okay. So next slide. So there are three main steps of this transfer of technology. Number one, research that produce technology. That's what we discussed. Second, assessment to develop site-specific technology. This is the point that I think we may probably miss. And it may also get delayed. I was just looking around, there were so many questions around regarding climate change and also certain specific areas. Look, I know that it is very difficult to answer for what should be a solution for a climate change and what should we do, because it's a global phenomenon. We probably don't have answers, but definitely we can reduce it. So to reduce these things, what are we supposed to do is the context. Now that's where it tells. Secondly, assessment to develop site specific technology may be an answer to reduce this kind of formidable negative context of global warming or climate change. Okay. Thirdly, counseling to apply technology in the field. That is where the practical reality comes. That is the who is going to implement? Our farmers. Okay. How do you teach him? How do you make him to understand that what is the output of this particular context? Okay. So these are the things that how this technological transfer is going to take place. These are the things that we are supposed to always carry in. Next slide, please. This I have borrowed from the Food and Agriculture Organ because I felt it was required. Okay. Now technology transfer, creation, dissemination, absorption. So this absorption is quite difficult proposition in the sense because it is not uniform. Technology is uniform. Its dissemination is uniform, but only thing is absorption has so many varieties. So that is the challenge that we are supposed to face. Okay. Adoptable, sustain, suitable, feasible, tailored, shared, effective, productivity, food security, adaptation, scalability, sustainable, environmentally, financially, socially, all those things. I just wanted to have this picture, what creation, dissemination, absorption. Okay. So this absorption is what I think we all probably put into. Okay. One of them tells adoption. Of course, fine. Adoption also is fine, but when you adopt it, you should know what you're going to adopt it. So first you should know what is that I'm going to put. Okay. So that is where the context is. Next slide, please. Opportunities. What opportunities we have? Of course, we have opportunities and challenges. More technology sharing. It is an opportunity because it is inevitable and necessary. What do you do with the technology if nobody is going to use? Because until you share, maybe with certain conditions, it is not going to do well. Okay. So it's better to see that you share technologies. Okay. Now, for example, there are cases in India in this context of this plant breeders point. I know everybody knows this Lays chips. The PepsiCo company manufactures this Lays chips. It has come out with a breed of potatoes which has less moisture. water content. So it got registered. It entered into an agreement with the farmers that they shall provide them the seeds and they shall grow and only give it to the Pepsi company. And it went on well, and the Pepsi company found that 5 farmers in Gujarat were doing the same thing. Now they don't know how they ended up in getting the seeds, all those things. And the PepsiCo company, of course, it's a very big multinational. They have got great lawyers. The lawyers send a notice to the farmers that so and so that you infringe the rights. Okay, you have no right to use the seeds without the permission, and you are supposed to pay damages of 1 crore each. So the matter came to Delhi High Court. The single bench stood with the farmers and told the Pepsi company does not have a right on this kind of seeds because the act prohibits it. But the Deval bench agreed with the Pepsi company, telling that mere technical context does not take away their right because they are invested certain context, okay, of energy and innovation. That is where IPR stands. So the Delhi High Court has tried to balance this proposition, maybe. But what I feel is that if this technology in the context of the seed is shared better, maybe with a negotiation, would yield better results. There are so many examples when you look across, when you type it across, you see some people are more fascinated with drones. That the drones can help or the robots can help the farming technology. Maybe that's why I told this particular technology that has evolved in US or Europe may not stand the test in India for the very reason that the land that what is there in US or Canada, which is huge, wherein manually or even mechanized machines cannot cultivate those crops. It's not possible. Even to sow a seed or for pesticides, manure, it's not possible because of the huge tracts of land that what I have. So it is drones becomes inevitable for them. They use helicopters or even small planes to carry out their activities. Okay, so that is also there. So the technology sharing in that context doesn't mean that it is positive or negative. It all depends from case to case. So innovative finance solutions always. Okay. Look, the story that why I use this chart, sorry, the slide of trying to do something connected with the farmer is that I was so disturbed in 2011-12 when the farmer suicide was so huge in India. So it has a reason that why these farmers commit suicide, and there are so many things that keeps on happening, the stories that keeps on coming both that way and this way. One thing, what was it that the affordability of a farmer in India is definitely very, very small. So instead of believing that these finance solutions, that if you think that these things should not be based on caste, but should be based on kind. If that kind comes into picture, I think it will evolve better results. And I'll tell you, I don't know how many of them know certain things, especially there are so many people doing good in farming, adopting these technologies. Mahindra is involved, the huge Mahindra company is involved in this farming. Tatas are involved in farming. Okay. And there is something called as e-Chopal. Okay. There are so many things that has evolved from last 25 years, especially. Okay. And they are all doing well and lessons are learned, but it is not uniformly probably spread. So this is an opportunity that we can definitely spread it across. Enabling environment. Obviously, we are supposed to not only produce or do some innovative things and try to implement it, but we need that environment condition also. Okay, in a country like India, every 100 kilometers, you find the soil changes, the environment changes, the crop changes. Okay, and probably across the globe, it is much more same, but India and the subcontinent and maybe differs from the other countries. Okay, local solutions. For everything, there cannot be answers. Okay, internationally, local solutions will always hold the key. I still remember Israel is one country which has adopted so many innovative technologies, especially in agriculture, because they've got a very small land holdings and they want to produce more. There was this technology of drip irrigation. Now, I don't know how many of you know this. It came from Israel, drip irrigation facilities, where you use water as an insulin that when you get admitted to the hospital, there is something called insulin is dropped into the body to get into energy. So this drip keeps on going into the body and you get energized. So it is not at one set, it is a drop. Okay, it is a drop. Okay, so the drop keeps on coming overnight and you are energized. So that technology was brought into India for definitely conserving water, because water wastage is huge in our country. Okay, now the North Karnataka context and the South Karnataka context clearly indicates that how water is used for agriculture. Drip irrigation came to India, but it was not successful for two reasons. Number one, the usage of it. Number two, the farmer did not know how would it yield results, and he does not have that patience to wait. Okay. So the government invested a lot of money. Even I come from an agricultural background a bit. We had some land, and I am telling this example out of my own experience that they brought in this drip irrigation to the coconut plantation what we had, but we were not able to sustain it for 2 years. We just again we brought out all and try to cut all those pipes, water. I was too young for all those things, but we didn't realize. But it continues to be so. Now, maybe the Mysore knows better the silk industry, how it has evolved, the silk's proposition, the Ramnagar side, all those things. Okay, so we need a local solution for these things. Traditional knowledge and indigenous know-how is a matter. So, as far as my understanding goes, this is an opportunity where we tell in ADR win-win situation. That can definitely be applied here. That if you are taking traditional knowledge and the innovative technologies together, it can be a win-win situation. Okay, because a local man knows what is better, and probably and creator knows what is better. Okay, in both the component, both the better comes, we can have the best. So probably this traditional knowledge and indigenous know matters counts a lot, because we should be in a win-win situation rather than win-lose situation or lose-lose situation. Next slide, please. Capacity building among local farmers and agriculture workers to ensure the technologies are not only adopted but also effectively used. So this is what I was saying. Somebody raised the point telling this adoption. Fine, we should adopt it, but adopt to my condition. I cannot definitely just, it's not a phone that we just take from US or somewhere else. Samsung phone comes from Korea, we take, and we use it as the other country use, but that is not the proposition in farming. We should try to see that this is used to the local conditions. If it is machinery, fine. But if it is coming to a seed or coming to fertilizer, definitely the local environment, the land, the soil, all counts. Okay, so we should definitely try to connect that and adapt that to the conditions where we are aware that this is what is going to happen if you're going to use this. It is all time consuming, definitely. It is time consuming. Learning process is a longer time in agricultural proposition. Policy support. Nation states to develop policies that create conducive environment for the adoption of new technologies. Definitely, yes. Okay, we expect that nation states to develop policies that create conducive environment. Of course, the management of the business by the global leaders would not probably bring this into picture at the foremost point. Maybe India is one which is leading to protect the interests of the farmers. Each country has their own interest, but the farming community, which is not protected by policies, is going to be really, really tough. Cultural and social consideration, that is where we stand. Now, understanding local culture, traditions, and practice is vital for the successful absorption of new technologies. Technology should align with local practice and ensure community involvement in technology adoption processes. So that is what the context is. So every society has its own culture and social considerations. So I'm not telling that that should be continued as it is. We should definitely move with times. And this is what the opportunity that we have to build in this context of technological transfer by taking this into considerations. Next slide, please. The challenges. So opportunities and challenges. The high cost of technology, financial constraints. It is for sure. Okay. Every farmer cannot afford. Okay. And today's globally, there are nearly 30 to 35% of the population involved in agriculture. Depending upon the nation state, it keeps on rising or it keeps on reducing. Okay. So everywhere I'll tell you the farmer is always on a losing side, or he is not in a better capacity to probably negotiate. Okay. And this farmer suicides is not only in India, it is across the globe. Even in US, farmers commit suicide because there is a crop loss or something else connected with the agriculture. Okay. Basically, financial constraints, high cost of technology deters the farmers to acquire those things. Okay. I also understand the effort that is involved in evolving, okay, or building something innovative things. Okay. The R&D that is spent, okay, and the years that is spent across. But as I stated that until you try to minimize, okay, I think it is going to definitely be on the challenging side. Now, very simple example, the solar, that what we tell renewable energy, till date, it is on a higher, costlier side. It is not a common man's buying capacity to have solar things until government gets involved to reduce it. Okay. So that's one example how things move. A contextual mismatch, restrictions of farmers' practice. Every farmer believes that if so and so things come, it will affect my practice or procurement or the way that I used to till my land and procure the crop. Okay, so that is where the seeds challenge comes. Okay, so my forefathers were just keeping in one gunny bag one of the crop so that they use it next year. Okay, or even they share with the neighbor farmer. Okay, but today that is not as easy as what it is. Okay, that is where the BT cotton got boycotted in India, the Montesco that came in for very reason that the few farmers who are growing on their land due to wind, natural context, it passed on the germ to the next farming land and they got spoiled. So this proposition, if it is uniform, uniform. If it is not, it is not. This challenge definitely we have mismatches that proposition. Okay, one farmer getting a seed from here, the ex-farmer who is neighbor to him getting seeds from here. Many a times due to natural flow of wind or air, soil, rain, it crosses over, and both may lose their crop. These challenges are definitely there. That's why we tell the farm connecting, okay, together maybe should have commonality, but it's not so easy. That's where it will restriction of farmers practices what they have been doing. So I think we should try to address this infrastructure deficiencies. Definitely, we can talk more and more infrastructure deficiencies. It's a challenge, especially in developing or underdeveloped countries. Knowledge and skill gap, obviously, definitely. Okay. That's what I told in the starting ICT. We having 2 degrees, 3 degrees, or 4 degrees of all those things, we believe that we can handle. No. Now we have got a smartphone. I don't know. We probably only 10% we will be using. Not that I don't want to use, but I have got a skill gap, maybe for various reasons. Okay. So if you imagine me, something like that, you just imagine a farmer. I know farmers are more smart in what they do. Okay. But that doesn't mean that the gap does not probably have. Okay. So this is what I think we are supposed to push across to the farming community. They have been doing, not that they are not been doing, but still we need this. This is the challenge. Of course, patent ticket is definitely a problem. We don't know because who has patented what. Okay. So as I told, the example of the PepsiCo, okay, is one example. Okay. Potato in India is too old. I know what that was Lalu Prasad Yadav told that जब तक रहेगा samosa में आलू, जब तक रहेगा लल्लू. Okay, that point is very clear that aloo is some of the staple food of North India. Okay, and nobody can take away that staple food from North Indian aloo. But if you're going to tell that it is patented, this seed is patented, somebody wants it, you cannot grow this kind of aloo. It is a problematic issue until we understand that so and so things have changed, and the numbering they do to the seeds, to the varieties, are all more technical. Even I don't understand until we fall into the line to realize what is this proposition. Enforcement and piracy. Okay, so the context is very simple. Look, especially at the last slide, what I showed, the traditional knowledge. I think there are so many of them who know, understand this TK, traditional knowledge. Okay, has been violated. Okay, and especially India is rich of those things. Okay, but unfortunately, that has not been substantially compensated. Okay, the piracy of movies is fine. Okay, but not of this kind of activities in agriculture. So that's a bigger challenge we are supposed to address. Policy and regulatory issues, again, it falls again off the government, how they are going to take this up. Okay, so there are so many things in innovation thing, but when it comes to technological transfer, we have all this divide of north and south, okay, or east and west, especially developed and developing countries. Okay, so until we stop seeing this as a commercial venture, try to put this activity as a human futuristic approach with values and certain content of commercial gains, which is very minimal, I don't think that we can survive the onslaught of what is coming out from the industry in the name of patents, or especially in the context of agricultural innovations. Okay, I'm not telling that it is wrong, but I'm telling until it is regulated well, until you fix the responsibility, accountability of these firms. Okay, there are many days you see up the paper, you find that farmers getting the seeds of so and so company. After 2 months, you know that it is not yielding anything. It has gone dry. It has failed. It is because the seeds were not good enough as what they promised. Okay, so none of us probably know the answer because you are supposed to wait for months. So this is a process altogether, a continuous process. So until these things cannot be regulated properly, these issues always remain. Okay, so with all my limited understanding and with my own experience, I thank you all for your patient listening. Any questions are welcome. I thank the organizers for the same. Thank you all.
Thank you, sir. Thank you so much for your valuable insights. Finally, I am pleased to invite our distinguished speaker, Professor Sanjit Kumar Chakraborty, Professor of Law, Director for Center and Law and Social Justice, West Bengal in UJS, to address on farmers' rights, traditional knowledge, and access to technology. Sir, before we proceed with your address, we would like to introduce you to our audience. May I kindly request Ms. Janvi Suresh to introduce you to the audience. Please proceed.
Sir. It's my honor to introduce a distinguished scholar, prolific researcher, and inspiring educator, Professor Dr. Sanjit Kumar Chakraborty, Professor of Law and Director of the Center for Law and Social Justice at NUJS, Kolkata. Sir holds a BA Law, LLB, and LLM from the University of North Bengal, where he received the University Medal in 2005 for academic excellence. He earned his PhD in law from the University of Budwan, focusing on intellectual property protection of plants and human rights issues, a pioneering intersection of innovation and social justice. With more than 2 decades of teaching and research experience, he has served at several leading law institutions, including the University of Kalyani, KIIT School of Law, Bhubaneswar, and since 2013, NUJS Kolkata, where he has contributed immensely to legal scholarship and academic leadership. Professor Chakraborty has authored over 38 publications across reputed national and international journals. His research encompasses intellectual property law, constitutional law, property law, and themes of law, justice, and globalization. A significant share of his scholarship is devoted to intellectual property rights in agriculture, biotechnology, and traditional knowledge, exploring their linkage with farmers' right, sustainable innovation, and food security. Among his most impactful work are intellectual property protection and utilization of GMCs in agriculture, analyzing the legal and regulatory regime in India, genetically modified seeds, intellectual property in agriculture. Has India addressed the challenges of commodifying plant genetic resource and farmers' right to access seeds? Intellectual property rights in agriculture research and development. Implication for the right of food in India. Intellectual property rights, agricultural biotechnology and food security. Issues and challenges in India. In the Indian agriculture under multilateral regional trade agreement. And protection of traditional knowledge and plant intellectual property rights, coming with the emerging challenges and issues in India. His earlier publications, such as Plant Intellectual Property Rights, Agricultural Biodiversity, and Farmers' Rights in India, in the Burdwan University Law Review in 2014, emphasizes the moral dimensions of innovation, human dignity, and environmental justice. While his core expertise lies in IPR and agriculture, his academic breadth extends far beyond. His articles, Relevance of Gender in Judicial Decision Making, in the International Journal of Public Law and Policy 2024, Data as Property Towards a Property-Based Model in the Global Privacy Law Review 2023, and the Exploration and Extraction of Deep Seabed Minerals in the Journal of Indian Law Institute 2022, illustrates his engagement with gender justice, digital property, and environmental law. Beyond publication, Professor has been a co-principal investigator for two major research projects funded by the NUJS Kolkata, one being the protection of traditional medical knowledge with special reference to Ajodhya Hills in Purulia, West Bengal. Second being the safeguarding of intangible cultural heritage and its impact on livelihood, focusing on Chahu mask-making traditions of Purulia. Both projects completed between 2022 and 24 reflect this dedication to connecting law with the grassroots realities, where intellectual property, livelihood, and cultural preservations intersect. Professor has guided doctoral research on feminist legal critics in judicial powers, actively participating in international and national academic forums. As a teacher, a researcher, and a mentor, he embodies the spirit of transformative legal education, combining intellectual rigor with social consciousness. Today, he will share his insights on the intellectual property rights and technology transfer in agriculture, a topic that perfectly aligns with his lifelong engagement with law, innovation, and sustainability. Please join me in extending a warm and respectful welcome to Professor Dr. Sanjit Kumar Chakrabarty.
Thank you. Thank you very much for all these kind words. Good evening, everyone. Am I audible? Am
Yes,
I
sir,
audible?
Yes, sir, you are audible.
Okay. Okay. Good evening, everyone. First of all, I want to thank Professor Dr. M.S. Benjamin, sir, Dean Faculty of Law and Chairman, Professor of Law, Department of Studies in Law, University of Mysore. Then I want to, thanks Sir Kudrat Hashmi, sir, for connecting me and informing me about this wonderful topic and the seminar. And my learned participants. Today, I'm going to, give some of my thought on the topic that is the traditional knowledge, intellectual property, and technology transfer. This topic is, quite close to my heart, and I tried to, read. Obviously, no one can complete the entire literature or entire legal development in one's lifetime. But I am trying to understand, and I am very much focused, since, my LLM time. that how the Indian knowledge system, is facing the problem, and or how the Indian knowledge system can cope up with so-called the global IP regime. For my some other academic activities, I missed the lecture, but when just I joined, Professor Vishwanath said, he was talking about that someone has to take the responsibility. Possibly, I will try to pose the question in a very different manner, that who owns the knowledge and who should take the responsibility. I want to start my discussion with a very small story, and it is known to many of you, I hope, that in the year 1995, the US Patent and Trademark Office granted a patent to the University of Mississippi for the use of the turmeric in wound healing. Now, who doesn't know that turmeric itself has some sort of antiseptic values and inflammatory values, and this is known in India as the grandmother's remedy, a piece of common knowledge that has been used for centuries. Even in the literature, it has been reflected that earlier in the battlefield, the soldiers used to carry turmeric powder along with their arms and ammunitions, so that if they get wound, in the battlefield, they can at least get the first aid treatment or the antiseptic treatment with the help of this turmeric powder. Now, when the patent was granted by the US Patent and Trademark Office in the year 1995, it was the Council of Scientific and Industrial Research, that is CSIR of India, had to fight a very costly legal battle to get the patent revoked. And ultimately, CSIR, went before the court along with the ancient Sanskrit text and the published paper, and established it as a prior art to reject or to revoke the patent. So this is one of the very simple illustration that how the traditional knowledge is being taken and being commodified or being commercially used, which actually owned by not only a particular community, because when we talk about the traditional knowledge, sometimes the traditional knowledge, it is always identify a very closed group of people, that is a particular community, that is the indigenous people or the indigenous community. But when I look at from a broader perspective, from a national perspective, that sometimes the community practices adopted by the nation itself. Okay, so the community knowledge or the knowledge which once described as an indigenous knowledge or the knowledge which was owned by a particular community need not to be limited only within the group of people or only within the indigenous community. So this particular illustration, that the turmeric patent, this is a particular illustration of that biopiracy. In legal terminology, we call it as a biopiracy. And from this particular story, I want to pose three questions, to go further or to, discuss. That can something known for generation after generation be invented? Does it fulfill the criteria of invention within the intellectual property framework? How does the global intellectual property system designed for new individual inventions and deal with old and collective knowledge? Because the traditional knowledge, it is a collective knowledge. It is a knowledge which is not very much documented. In number of literature, it is mentioned that sometimes even the traditional knowledge are embodied through folklore, through song, through poet, okay, through some artistic activities. And these were treated as a sacred one, and it was treated either the property of none or the property of all who are the members of that particular community. So I will try in my discussion that to examine that how the international legal framework, treat this particular collective knowledge or the individual inventions, because so far the traditional knowledge and the other form of intellectual property, more specifically if I say the patent. Patent, generally one person claim that I have invented something which is novel, it has the industrial application, and it has the inventive steps. So if I establish the three criteria under the Patent Act 1970, I am entitled to get patent, and the patent is generally given to the individual. And it is the state sovereign act or the sovereign policy to give patent or not to give patent. And while giving this patent or while conferring any sort of intellectual property protection system, it is actually quite pro-proof. Okay, that means I will give you the commercial rights. In lieu of that, you have to disclose that how you have developed it, so that the society can get benefit out of that existing knowledge. Now, the traditional knowledge actually doesn't come within any of the framework because of its own peculiar character, which I will discuss later. The next question I am going to address in my lecture, that when that knowledge is used to create valuable technologies, who should benefit? And how the technology can be transferred, who originally owned this particular knowledge. Now, this issue actually is commonly known as the technology transfer, which is a very debated issue so far the entire IP regime is concerned. But if I look into the very fundamental clash of legal paradigms, then we must understand that while discussing about the traditional knowledge within the framework of the intellectual property law regime, okay, national IP law or international IP law, it doesn't make any sense, because after TRIPS 1995, all the WTO members or the negotiating countries, they actually already framed their domestic legislation at par with the TRIPS standard. Even now we are saying that we entered into the TRIPS plus regime. That means we are no more happy with the TRIPS minimum protection. We need some sort of broader protection. That is why we entered into some sort of bilateral or multilateral agreement. For example, in the name of ACTA, etc. Now, on the one hand, on the one side, if we look into the Western IP model, the Western IP model, it is very much individual in nature, it is private, and it is proprietary. That means it intends to give some sort of proprietary interest. If I look into the goal of the Western IP system, the goal is to incentivize the new inventions through a temporary monopoly. Key criteria: novelty, inventive steps, and industrial application. As I already mentioned, that in case of patent, you have to find out that it has the novelty, it has the inventive steps, and it has the industrial application. And if we look into the form of this particular knowledge, then it is quite codified, written, and well documented. Even if we look into the Patents Act 1970, the patent protection can be given only when there is a specification, and the specification, it must be detailed. It must be detailed so that any person who is very much familiar to that particular art or science, he can reach to the same result by following the same procedure. Now, in the books that is the Intellectual Property Rights and Development written by Jashri Bottle, one point the author mentioned that intellectual property is nothing but the byproduct of the Western culture, because knowledge was never treated as a property in India so far the Indian culture is concerned. In our ancient text, we always you can always see, or even we sometimes use to say that Mahajana Gato Shapantha. That means the person who is having the supreme knowledge, I have to follow him. And for the purpose of following, there is no need to pay him. So this was our culture. But as I stated, the Western philosophy of the intellectual property rights as it is intended to protect, it is very much different. It is very much industrial in nature. It is proprietary in nature. It is private in nature. And it intends to give some sort of economic rights to the right holder. Now, if we look into the characteristics of the traditional knowledge, please try to, take this point quite seriously, that the entire discussion of the traditional knowledge, it gives you the idea that the nature of the traditional knowledge is that it is collective, communal, that means, the community owned, and often sacred. Sacred, that means, you can sell it, you can commercially, use it. You can take money by sharing this particular knowledge. What is the goal, or what is the specific goal so far this particular traditional knowledge is concerned? Actually, every traditional knowledge, each and every category or the types or the different types of traditional knowledge, it has been developed on the basis of the local need, okay, and on the basis of the need of that particular community who are residing in a particular geographical territory or in a particular geographical location. Obviously, I'm not talking about the GI. GI is a totally different thing. Now, the goal of the traditional knowledge is always to ensure the community survival and the sustainability, so that the community can survive, so that the community can go for a sustainable development aspect. If you look into the key criteria, it is not like the Western philosophy of IPR. The key criteria for traditional knowledge is always the cultural value, intergenerational transmission, and proven efficacy over time. That means that particular knowledge is being practiced generation after generation. So it has the intergenerational transmission, that one generation, when they are not there, the next generation, they will own it. And it has the proven efficacy. That means there is no failure, or turmeric as an antiseptic, or turmeric, it has some sort of elements which can cure some sort of skin disease. So it is proven, and it is cultural. It has the cultural values. Just look at the use of the turmeric, in all our religious practices, even in our personal affairs like marriage, and all other ceremonies are concerned. And the form, what is the form of this traditional knowledge? How it is being restored? How it is being kept? The form of the traditional knowledge is that it is always oral, experiential, and uncodified. People used to remember it. So the legal problem with the traditional knowledge is that it was treated as res nullius, that means the property of nobody, or it is the property of the entire community. It becomes a property within the public domain, and all the members of the community, they were free to take it away, or they are free to use this particular traditional knowledge. Now, when the intellectual property system has developed, and when the people started commercializing the traditional knowledge, then ultimately it creates a problem, like the problem which I have already identified, that the biopiracy. Now, what is the legal definition of biopiracy? If we read the literature, then the CBD or other, statute, domestic statute, the meaning, the terminology, it has been defined that the appropriation of genetic resources or associated traditional knowledge without prior informed consent to the communities without fair and equitable benefit sharing. And this is very much happening in many sectors, more specifically in the Ayurvedic, to the point. But in agricultural sector also, this is, the misappropriation of the traditional knowledge is also very common. So it is not just a theft. If we look into the definition, it is not just a theft, it is the use of the IP system to legitimize the theft. Someone from the indigenous community, he did not file a patent on a very well settled knowledge or well settled formula. On the ground of that, you are eradicating him or you are preventing him from exploiting that particular knowledge. And you are collecting the information, you are getting all the necessary information in relation to the traditional knowledge from the community itself, and subsequently you are commercializing it through the mechanism of what? Through the mechanism of intellectual property rights. So, Bandana Shiva, the monoculture of the mind in this book, Philip Collett in his writing, there are many other people, all of them, they say that, that intellectual property right system actually, it gives these people an opportunity to legitimize the thing. Now, what is the misappropriation? There is a difference between misappropriation and monopolization. All of us, we know that intellectual property rights to some extent gives you the monopoly. For example, if you give patent, you will get the monopoly to manufacture it, to sell it, to import, to export on a particular product or a particular process now. Okay. So it gives some sort of monopoly. But what is misappropriation? Misappropriation is that you are taking, which is the property owned by someone else, and you are not giving any sort of protection or any sort of benefit to the people. That means, to the person or to the community who are owning it. So, for example, just in the agricultural sector, if I take this example, for example, a company or a researcher, takes a plant sample or knowledge, about the medicinal plant from a particular community, and he is using it to commercial sell or commercial exploitation. Rather, let me use the terminology of literature, IP literature. That is, this plant sample which is known for a medicinal plant, and I came to know from a particular community, and without informing them, I collect that particular plant and I am commercially exploiting it. Now, the original knowledge holders are legally prevented from using their own knowledge, because if I just imagine that the patent of turmeric, it was not revoked, or it has not been revoked, then what would happen? What would be the scenario? The scenario would have been that I can't use the turmeric, rather it is legally prohibited. So in such circumstances, if we look into the entire IP pyramid, that is the IP legal pyramid, you will find that internationally, there is a tug of war, within the IP legal framework. if we read the TRIPS agreement carefully, the TRIPS agreement actually it sets the mandatory enforceable minimum standard of IP protection. This is number one, the characteristics of the TRIPS agreement. TRIPS is also used as a private engine, for privatization of knowledge. So the traditional knowledge, which was the knowledge of the community, now it becomes the private knowledge, and now it is being used. And the TRIPS agreement doesn't speak much about the traditional knowledge, or rather it has a very important provision in relation to the technology transfer. But so far the TK is concerned, this is, it did not find any, visible place or the visible, space within the discourse of the TRIPS itself. But there is another international instrument, that is the CBD, the Convention on Biological Diversity. And along with this CBD, we can take into consideration the Nagoya Protocol. So if we read both the documents together, actually earlier what happened, the CBD, before CBD, from the agricultural context, I must also mention the International Undertaking for Plant Genetic Resources for Food and Agriculture, popularly known as IU, which subsequently converted into the IT, that is the International Treaty on Plant Genetic Resources for Food and Agriculture, ITPGRFR and IUPGRFR. And after that, the CBD came. And the most important thing in the convention was that for the first time, the CBD mentioned that all the plant genetic resources, these are not the property res nullius. Rather, this convention for the first time established the sovereign right of the state over its genetic resources. Not only that, the CBD within its framework, it's mandated that you can collect the plant genetic resources, but it must be with consent. That is, the prior informed consent must be obtained. That is PIC. And not only the consent, rather when you are taking any plant genetic resources and subsequently you are using it through technological means for commercial purpose, you are using it, in that case, the fair and equitable benefit must be shared with that particular community. And the most important provisions, due to the shortage of time, I'm not going into the entire article. If you look into Article 16 of the CBD, it explicitly mandates that access to and transfer of technologies that using genetic resources. Now, here I want to explain a little bit. If you believe in the theory, which is popularly known as the Locke egalitarianism, it simply says that a person can be suffered for the wrong which he has committed. But we should not allow any person to suffer for the wrong in which he has no contribution. Now, whether we agree or disagree, we have to accept one fact, that the natural resources in the world have not been divided, or it is not available in all the countries or all the territorial location in a very equal manner. Some countries are very rich with some plant genetic resources or some mines or minerals, On the other hand, there are some countries which are not so rich from the biodiversity aspect. But at the same time, it is also true, or it is also a fact, that a country where the biodiversity is very much rich, okay, but they don't have the technology, to use this genetic resources, including the plant genetic resources from the agricultural viewpoint, for a better use. They don't have the plant genetic resources, but they have the technology. Now, there are some countries, they don't have the technology, but they have the genetic resources which can be used as a raw materials. And there is another country which have the technology, but they don't have the plant genetic resources or the genetic resources which needs to be used as a raw materials. Now, after the decision of the Diamond versus Chakraborty by the US Supreme Court in the year 1980, that anything and everything, quote unquote, could be patented provided that there is a human intervention. It simply means, actually, this particular decision opened the floodgate for the patent on living organisms, including the patent, for the plant patent, okay, or patent alike rights. Now, the legal conflict is that if you look into two documents, that is the TRIPS agreement and the CBD, TRIPS talks about the intellectual property rights, it talks about the commercialization, and it talks about what should I say, that is how to how to set up the minimum standard of protection of intellectual property rights throughout the world. Perhaps TRIPS was not very much focused on the protection of the community rights or the rights of the individual or rights of one particular group of people. On the other hand, the CBD, along with the Nagoya Protocol, according to me, these are a little bit human rights oriented documents. Actually, it intends to say that the actual owner of the plant genetic resources, they must be given the benefit out of the technological innovation or the technological improvement which you are going to make in relation to the plant genetic resources or the genetic resources. So there is a some sort of tussle, that which one we should follow. Should we go for the TRIPS agreement or should we follow the CBD? Here I want to mention, one of the resolution taken by the United Nations Council for Human Rights Protection, that is resolution number 26 of 2000, that if there is any inconsistency between the trade rules and the human rights objectives or the human rights law, let me put it in other way, that if there is any conflict between the trade law and the human rights law, obviously it is the human rights law which will prevail. That means we have to make some sort of adjustment so that the intellectual property rights can be a mechanism or can be used as a tool to fulfill the human rights objectives. And Professor Lawrence R. Helfer, quite enormously, he is writing on this particular issue, that how the intellectual property rights regime and the human rights can coexist together. Now, the legal conflict which I tried to identify between the TRIPS and CBD, it is to be taken into consideration quite seriously. And then we have to look into the rights of the indigenous people who are the actual owner of the traditional knowledge. And if we look the international regime or international legal framework, because in absence of any domestic legislation or in absence of any domestic legal instrument, there is no other option but to rely upon the global norms, because ultimately it is a consequence of so-called globalization. So the globalization did not take place only in the economic aspect. Globalization means it actually impacted, or it influenced every sector through which the human beings, they are interconnected throughout the world. So in the legal norms or the norm settings, this is also known as the transnational hierarchy of legal norms. So transnational hierarchy of legal norms, if we follow this provision, even there is something called that judicial globalization. Okay, that means when judiciary is relying upon the foreign laws or the decision given by the foreign courts, this is known as the judicial globalization. So the United Nations Declaration on the Rights of the Indigenous People, this particular declaration, strengthen the human rights dimension, claiming control over the TK as a collective cultural right. I repeat that this UN Declaration on the Rights of Indigenous People, it strengthen the human rights dimension. That I always say this thing, that when your positive law does not serve the purpose, or it becomes some sort of unruly horse, then it is either in the name of the natural justice or in the name of the human rights, you can tame it, okay, to serve the public purpose. So the TK was described as a human right, and the TK was described as a collective cultural rights of the indigenous people. Now, faced with this international impasses, country like India, where the traditional knowledge is very much common, and there is a high chance that we may be the victim of biopiracy, what we did actually, or what is the legal framework? How can we challenge this biopiracy legally? So while discussing about the national legal system, the first one, it comes to my mind that the first thing is the CBD. And on the basis of the CBD, we have enacted a legislation in the year 2002. And if you read the legislation, that is the Biodiversity Act 2002, you will find that though the matter intellectual property has not been directly addressed, okay, but there are number of provisions, which makes the mandate of the CBD is quite visible within the national legal framework. For example, of what I mentioned from the CBD, it says that prior informed consent, it is to be obtained. The Biodiversity Act says that any foreigners, in case of any foreigners, they can't collect, they can obtain any genetic resources, including the plant genetic resources, without the prior written approval from the National Biodiversity Act Authority. Section 3 of the biological resources for foreigners, it makes it compulsory. And when the matter comes as to the technology, then the National Biodiversity Authority can impose a condition while granting approval to collect the genetic resources, and they can condition it that you must share the technology by using these raw materials or the resources which you are collecting from us. They can also impose a condition like the joint research and development, licensing of the resulting technologies, okay, and they can also go for some sort of mutual understanding which ultimately build up the research capacity in India. So before 2002, if I say because the Plant Variety Protection and Farmers' Right Act, it also talks about the equitable share, etc., etc., gene fund, etc. But I think that technology transfer aspect, so far the agricultural part is concerned, it has been, taken care of, to a large extent under the Biodiversity Act 2002. As I mentioned that the Plant Variety Protection and Farmers' Right Act 2001, though the matter has not been directly addressed, but it mentioned that the farmers, the Indian farmers, they are the breeder and the conserver of the genetic resources. So, in one sense, in agriculture in India, many information related to agricultural practices are treated as a traditional knowledge. And those knowledge, including those traditional varieties of, plant, which has been developed by the Indian farmers and the Indian conservers, they have been given the ownership right. That means it is not only the breeder, plant breeder, quote unquote, in a scientific sense, they will be treated as a breeder. Rather, the Plant Variety Protection Act, it actually emphasized that the farmers in India, they must be equated with breeder. And not only that, they also have been given the same right, just like the breeder. They can save, they can use, they can sow, they can resow, they can exchange, they can share, or they can sell of their product. Okay. And the products, it also protects the informal seed system. That is the agricultural chain, that is the seed, which is the most important, the second most important agricultural input for agricultural production. So the benefit sharing, if you look, as I already mentioned, that it also talks about the benefit sharing. That, for example, if the formal plant breeder collect any plant which has been developed and conserved by the traditional farmers centuries after centuries, generation after generation, by using their traditional knowledges, and if it subsequently improved through scientific method, for which there is some sort of research and development cost, so obviously that scientific breeder, he can sell it, or rather he is entitled to get some sort of intellectual property protection on that. But we have to keep it in mind that there are raw materials which the scientific breeder he collected it from the farmer's field. Again, I want to quote Bandana Shiva, who said that the entire problem in relation to TK and farmers' right started when the genetic materials traveled to the scientist laboratory from the farmer's field. So being a practical, being reasonable and practical, and being a student of law, obviously I can't take only one-sided view. I can only say that when some improvement or the technological development is taking place, obviously he must be given some right. But at the same time, the people who preserve that raw materials, that is generation after generation, through their traditional knowledges, they must also be given some benefit out of that. Now, what we did, except this to a statute more specifically, one of the most important thing we did, that is the TKDL, that is the Traditional Knowledge Digital Library. Actually, the establishment of the Traditional Knowledge Digital Library, it was a very defensive approach. At the very beginning, when I gave the example about the turmeric patent by US Patent and Trademark Office, I said that the Council for Scientific Research Association, they went before the court with the Sanskrit, text to establish that, listen, go through this. This is our culture. This is the knowledge, which we have. This was within the public domain. How can you ask for, patent? Because it is a novelty. The thing which is already in public domain, how can you, claim as a novel one? So that traditional knowledge digital library is nothing, but a documentation process. Because one of the problem, or one of, I can say that it is traditional knowledge is quite vulnerable, on the face of the intellectual property right reason, because it is not well documented. So the documentation part has been taken care of by this TKDL system. And by translating, the ancient text into multiple languages and putting them into the searchable database, obviously you go for the patent search. Okay, so how can you establish the prior art? So unless and until I can find it, so the TKDL giving all the information. So whenever any person, before filing the patent application or after filing the patent application, if the search is made by the patent office itself, so that he can see that this is a prior art and this was, it was in existence. It was in existence. So actually the TKDL, it works as a shield. It is not a sword. TKDL itself doesn't create any right. Rather, no one can, take away our traditional knowledges through the mechanism, or I can say through a very strict mechanism of IP that has been taken care of by the TKDL. Now, when we talk about the technology transfer, still it is a very problematic aspect, because many times what is happening, that the technology transfer aspects is not being fulfilled, because CBD it says that you must give some sort of equitable benefit. You must be ready to share your benefit in a very equitable manner. And this equitable benefit sharing does not only mean the royalties, but unfortunately the multinational companies who are involved in the agri-biotech business, they mean that, if I am using your plant genetic resources or the genetic resources as a raw materials, by way of giving royalty, I can, compensate you. But the CBD, and along with the reading of the Biodiversity Act 2002, we can see that it also talks about the collaborative partnership. That means you give us access to your resources and knowledges, we will give you the access to the science and technology that results. That means, some multinational company having, very good technological development or the scientific aspect, and we have the rich biodiversity, we have rich traditional knowledge. So we are giving you the access to the traditional knowledge or to the rich biological resources, including the plant genetic resources. So whatever may be the technological development, you must give access to it. In reality, this transfer of resources, it is taking place from global south to global north, but and it is only in lieu of the royalties, but the technology is not coming. This is the problem we are still facing. Even I can say there is a backlog in the transfer of technology capacity, because the technology, it is not coming. It is not coming from the global north. Furthermore, with the development of genetic science or the technology, now we are facing challenges which is called the digital sequence information. And the digital sequence information, that is, without your knowledge, the genetic sequence information, it can be taken away by any other person, whereas the origin of that particular resources is in your country. So a researcher, just let me give you one example. For example, a researcher visits a community, sequences the DNA of a medicinal plant, and upload the genetic code to a public database online. And then use the digital information to engineer the synthetic biology product in lab halfway across the world. What will happen in that case? Actually, I am not aware. So this is a problem with the with the development of the information and communication technology. Now the question, after having discussing a few things or the few areas, I have a very simple question: that how can we protect our traditional knowledge, more specifically in the field of the agriculture, or how can we protect our plant genetic resources from this biopiracy? And more specifically, how can we address the issue of the digital biopiracy, which is now a threat? Actually, many scholars, they suggested that traditional knowledge is not a very suitable subject matter which can be addressed by the IPR, because IPR, more specifically, it can't be covered through the law of patents because it requires some sort of authentication. Okay, it must be documented, it must be well described, and there must be a certainty. So the patent law can't address the issue. So many of the authors, they suggested for a sui generis legislation, that means a legislation of its own kind and another legislation to protect the traditional knowledge. But I with due respect to them, I want to differ on this point, that I believe that we have multiple legislation. There is no doubt of the legal principles. What I believe, that if there is any doubt or if there is a lacuna, the lacuna lies with the political will and the enforcement. India is already, it is already overcrowded with so many legislation. Okay, someone rightly said that India is a paradise of legislation. Okay, here we make the law on every subject, on every area. So my suggestion is that instead of making another law, can we bring some modification or changes within the patent law and the Plant Variety Protection Act 2001 and the Biological Diversity Act 2002? And where the reforms or where the changes are to be brought into? Actually, there are three areas I have identified. First of all, there must be some provision in the Biological Diversity Act itself, which will legally recognize the collective ownership of the TK by a particular community. This is number one. Number two, we have to make it mandatory and enforceable, the technology transfer aspect. It is not merely a promise. It should not be merely a condition. Okay. Rather, it must have enforceability. Now, how to enforce it? This is a separate discussion, that is the enforcement of IP. So there are some problems, but enforcement mechanism must be there. And there is another thing which sometimes overlooked by many scholars, by many people, that is, we must recognize the customary laws. Because when I visited, for my own research, I found that for the purpose of the protection of traditional knowledges, including the genetic resources and etc., the community, they have a very inbuilt system, in the name of the customary laws. So while making changes in the Biodiversity Act 2002 or the Farmers' Right Act 2001, we must look into, or we must take into consideration that what customary laws do they have, and we can make the law, enforcing the traditional knowledge in the line of the customary law, because already the customary law, it has the acceptance within the community itself. So broadly, I just wanted to highlight these are the issues, in relation to traditional knowledge, its ownership, its protection under the IP design, and the technology transfer aspect so far the agricultural sector is concerned. Obviously, this topic, it has its own importance, but it is not taken quite seriously by the people more nowadays. Actually, this subject is being discussed, and many people, they took interest to research on it. But as a future lawyer, judges, and the policy makers, we must ask the question to ourselves that how can you design a single international or the single international legal regime to bridge the gap between the TRIPS agreement and the CBD provision? Because the CBD objectives and the TRIPS objectives is quite different. So we can, though for the argument I say that there is a resolution, but internationally we must develop certain legal infrastructure so that we can harmonize this both international treaty. One is the CBD and another one is the TRIPS agreement. And that is why it is not just an academic exercise. It is about justice, equity, and reorganizing the guardian of our planet's biodiversity, that they should be the beneficiaries of knowledge and they must be given their due, which they have nurtured for the millennium and generation after generation. And technology transfer aspect, it must be taken quite seriously. It must have the enforceability, and there should not be any backlog of technology transfer from global north to global south. That is why the regional cooperation. We have international mechanism or the international IP design, but we must be given, or rather, we must prepare ourselves, to bargain with them. Because obviously, the tech-savvy country, they will try to impose the terms and conditions as per their convenience. But we must be also ready with our own terms and conditions. Because, we are very rich so far our biodiversity is concerned, so far our traditional knowledge is concerned. So these are going to be used by them in a very scientific manner. So these are the raw materials. Without raw materials, they can't work, they can't develop. So if we can protect our traditional knowledge, if we can protect our genetic resources from illegal manipulation or the illegal use or the misappropriation, or which is popularly known as the biopiracy, obviously we can bargain with them. And for that, we must need a very concrete negotiating approach, so that we can negotiate with them. And obviously, while negotiating with them, we must follow the national IPR policy, which we already adopted in the year 2016. With this, I thank all of you, and this floor is now open for question. If you have any question, any query, please.
Thank you, sir, for such rich deliberation that anchoring traditional knowledge to international law and BITs and so on. So as we conclude today's program, we found some reflections on how legal frameworks can transform sustainability and empower technological transformation in agriculture service. So I would like to request Shrimati Sheila Ganesh Ma'am, Assistant Professor, GSS Law College, to deliver a vote of thanks for today's program. And for the other participants, we welcome them for tomorrow's program at 2:30. Ma'am, the floor is yours.
Yes. Now that we have arrived at the conclusion of today's session of the 2-day international webinar on legal governance and green technologies for sustainable agriculture, I deem it to be a privilege to propose this vote of thanks on today's occasion. I sincerely thank the chief patrons, Professor Dr. Lokanath N.K., Honorable Vice Chancellor, University of Mysuru, and Srimati M.K. Savita, K.S., Registrar, University of Mysuru, Karnataka, for allowing us to conduct such insightful events. I extend my deep sense of gratitude to the patrons. First of all, Professor Dr. M.S. Benjamin, sir, Dean, Faculty of Law, Chairman, Department of Studies in Law, University of Mysuru, for making this collaboration happen and also for being with us throughout on this day. Thank you very much, sir. Sincere thanks to Professor K. Suresh, Chief Executive, JSS Law College, Mysuru, for his support and for this 2 days international webinar event. In his absentia, I thank him as well. Thank you very much, sir. I also thank Dr. Vasant Kumar Kupara, Managing Director and Chief Scientific Officer, Green Life PropTech Private Limited, Mysuru, for being part of this collaborative initiative. Thank you, sir. On behalf of the joint collaboration initiative, I render my sincere thanks to today's resource persons for the meticulously handling various sessions and with their experience and insightful thoughts. We thank Professor Dr. Shaiwal, Satyarthi, Professor, Faculty of Law, University of Delhi, for handling the session on legal and regulatory frameworks for green and sustainable agriculture. Thank you, sir. Further, Professor Dr. Sreenivasulu N, Professor of Law, the West Bengal National University of Juridical Sciences, Kolkata, India, for handling the session on the topic Governance of Biotechnology, GMOs and Eco-Friendly Practices. Thank you, sir. Professor Dr. M. Vishwanath, Professor, Dean, Faculty of Law, Department of Studies in Law, Karnataka University, Dharwad, for handling the session on intellectual property rights and technology transfer in agri-innovation. Thank you very much, sir. Also, we thank Professor Dr. Sanjit Kumar Chakravarti, Professor of Law and Director, Center for Law and Social Justice, West Bengal National University of Juridical Sciences, for handling the session on the topic Farmers' Rights, Traditional Knowledge and Access to Technology. Thank you very much, sir. I also extend my sincere thanks to the organizing members, Dr. N. Manishri, Principal, JSS Law College, and also the convener. Thank you very much, ma'am. Mr. Syed Kudrat Hashmi, PhD Research Scholar, Department of Studies in Law, University of Mysuru, for being organizing member. Thank you, sir. And other student volunteers for their support and coordination as well. Thank you, volunteers. And I also extend my warm, sincere thanks to Mr. Madhukumar RN, System Analyst, for his all-round technical support. Thank you very much, sir. Last but not the least, I thank all the participants across the globe for their keen interest and patient listening throughout today's session. Thank you very much. I expect the past participants to also give adequate support for tomorrow's event and so that it can become more meaningful and successful. Thank you, one and all. Thank you.
Okay, before we leave this session, I know again, let me express my gratitude to Professor Benjamin, sir, and to each and every member of the organizing committee who took the initiatives to conduct this particular conference. It is a very wonderful opportunity. And these areas are actually hardly, very few seminars or conferences are being organized on this particular area. So for this reason only, I want to congratulate the University of Mysore, that you people are taking these nuance areas of law for detailed deliberations. So once again, I convey my deep regards and gratitudes to all the members who are associated with this conference. Thank you very much. Greetings from Kolkata. Namaskar.